ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ವಿಧಿಪ್ರಜ್ಞಾ ಕರ್ನಾಟಕ ಕಾನೂನು ಸ್ವಯಂ ಸೇವಾ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ವಿಧಿಪ್ರಜ್ಞಾ ಕರ್ನಾಟಕ ಕಾನೂನು ಅಕಾಡೆಮಿಯ ಒಂದು ಸಂಯುಕ್ತಾಶ್ರಯದಲ್ಲಿ ಇವತ್ತಿನ ದಿನ ಜಿ ಚಂದ್ರಶೇಖರಯ್ಯ ರವರು ವಿಶೇಷ ಒಂದು ಉಪನ್ಯಾಸವನ್ನ C.P.C ಅನ್ನೋ ಸಬ್ಜೆಕ್ಟಿನ ವಿಚಾರವಾಗಿ ಕೊಡಲು ಬಯಸಿದ್ದಾರೆ. ಸೊ ಇವರು ಸಾಕಷ್ಟು 36 ವರ್ಷ ಒಂದು ಕಾನೂನು ವೃತ್ತಿಯಲ್ಲಿ ತಮ್ಮನ್ನ ತಾವು ತೊಡಗಿಸ್ಕೊಂಡಿದ್ದಾರೆ. 14 ವರ್ಷದಿಂದ ಕಾನೂನು ಉಪನ್ಯಾಸಕರಾಗಿ ಸಾಕಷ್ಟು ಒಂದು ಕಾನೂನು ಕಾಲೇಜುಗಳು ಸಂಸ್ಥೆಗಳು ಇಂದ ಕೆಲಸವನ್ನ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇರುವಂತ ವಕೀಲರ ಒಂದು ಸಂಘ ಅದರಲ್ಲಿ ತಮ್ಮದೇ ಆದಂತ ಚಾಪನ್ನ ತಮ್ಮದೇ ಆದಂತ ಸ್ಥಾನಮಾನನ ಗಳಿಸಿ ಇವತ್ತು ಬಹಳ ಒಂದು ಪ್ರಸಿದ್ಧ ವಕೀಲರು ಹಾಗೂ ಬಹಳ ಪ್ರಬುದ್ಧತೆ ಹೊಂದಿರಂತ ವಕೀಲರು, ವಾಗ್ಮಿಗಳು, ಸಾಕಷ್ಟು ಜ್ಞಾನವನ್ನ ಪಡೆದಿದ್ದಾರೆ ಅಂತ ಒಂದು ಬಹಳ ಒಂದು ಪ್ರಸಿದ್ಧವಾದಂತ ಒಂದು ಹೆಸರನ್ನ ಇವತ್ತು ಪಡ್ಕೊಂಡು ತಮ್ಮ ಒಂದು ಸೇವೆಯನ್ನ ಈ ಒಂದು ಸಂಸ್ಥೆಗೂ ಸಹ ಈ ಒಂದು ಕಾನೂನು ಅಕಾಡೆಮಿ ಅಲ್ಲಿ ಇರುವಂತ ಒಂದು ಅಭ್ಯರ್ಥಿಗಳು ಏನು ಕಾನೂನು ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರ ಒಂದು ಹುದ್ದೆಗೆ ಎಕ್ಸಾಮಿನೇಷನ್ಗೆ ತಯಾರಿ ಆಗ್ತಾ ಇರೋಂಥ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಉಚಿತವಾಗಿ ಸರ್ ನಾನು ಮಾಡ್ಕೊಡ್ತೀನಿ, ನಮ್ಗೆ ಯಾವುದೇ ತರ ಹಣ ಬೇಡ ಅಂತ ಹೇಳಿ ತಮ್ಮ ತುಂಬ ಹೃದಯದಿಂದ ಇವತ್ತು ಬಂದಿದ್ದಾರೆ. ಅವ್ರನ್ನ ನಾವು ಬರ್ಮಾಡ್ಕೊಂಡು ಈಗಾಗ್ಲೇ ನಮಗೆ ಒಂದು ಉಪನ್ಯಾಸವನ್ನ ಕೊಟ್ಟಿದ್ದು, ಈಗ ಮತ್ತೊಮ್ಮೆ ಇನ್ನೊಂದು ಉಪನ್ಯಾಸವನ್ನ ಕೊಡ್ತಾರೆ ಇವತ್ತು. ಇದನ್ನ ನಾವು ಆಲಿಸ್ತಾ ನಾವು ಈ ಒಂದು ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಭಾಗಿಯಾಗೋಣ ಅಂತ ಹೇಳ್ತಾ ಸರ್ ನಾನು ಅವ್ರನ್ನ ಬರ್ಮಾಡ್ಕೊಡ್ತೀನಿ. ಸರ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್ ಫಾರ್ ಗ್ರೇಸಿಂಗ್ ಅಸ್.
Thank you, sir.
So over to you, sir.
Sir, thank you. Good morning to everybody.
Good
So
morning,
shall we
sir.
start?
Yes, sir. We shall start, sir.
Please. So good morning, sir, everyone who present here. Friends, in the previous occasion, we have discussed about the C.P.C. Today, we are going to discuss about C.P.C. Friends, I have formulated certain ideas about what is the relevancy of C.P.C for our purpose. Illi ಮುಖ್ಯವಾಗಿ ನಮಗೆ need based discussion is important. So I have examined few of the question papers and I've selected a very repeated questions which we have to answer immediately. That's called a need-based study. In that way, I have formulated and selected few sections and orders and rules in C.P.C. so that we will evolve the meaning of it. Friends, you know all, a civil procedure code deals with the nature of civil suits and the relief sought. The first and foremost thing, who has to appear before the court? Who has to appear before the court? It is a person who have got an inherent right. That is most important. Person who have got an inherent right to claim certain rights when such rights are infringed or affected or damaged.
Excuse me, sir. Pardon, sir. ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಕನ್ನಡದಲ್ಲಿ ಉಪನ್ಯಾಸವನ್ನ ಮುಂದುವರಿಸಿ ಸರ್. ಯಾಕೆಂದ್ರೆ ಕನ್ನಡ ವಿದ್ಯಾರ್ಥಿಗಳು, ಕನ್ನಡ ಮಾಧ್ಯಮ ವಿದ್ಯಾರ್ಥಿಗಳು ಸಹ ಇದ್ದಾರೆ. ಹಾಗಾಗಿ ಸ್ವಲ್ಪ ಅವರು ಒಂದು ಸ್ವಲ್ಪ ಕನ್ನಡದಲ್ಲೂ ಹೇಳಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಆಗ್ಬಹುದು, ಖಂಡಿತ. ನಾನು ಕನ್ನಡದಲ್ಲೇ ಹೇಳಲಿಕ್ಕೂ ನನಗೆ ತುಂಬಾ ಆಸಕ್ತಿ ಇದೆ, ಹೇಳ್ತೀನಿ. ಸಿವಿಲ್ ಪ್ರಕ್ರಿಯೆ ಮತ್ತೆ ದಿವಾನಿ ಪ್ರಕ್ರಿಯೆ ಅಂತ ನಾವು ಕರಿತೀವಿ. ಇಲ್ಲಿ ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ಒಂದು ಹಕ್ಕು ಪ್ರಾಪ್ತವಾಗಿರ್ತಕ್ಕಂಥ ಹಕ್ಕಿಗೆ ಚ್ಯುತಿ ಬಂದಾಗ ರೈಟ್, ಆ ಒಂದು ಹಕ್ಕನ್ನು ಪ್ರತಿಪಾದನೆ ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕೋಸ್ಕರ ಈ ಸಿವಿಲ್ ಪ್ರಕ್ರಿಯೆ ಸಂಹಿತೆಯ ಅಡಿಯಲ್ಲಿ ಆತ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಮೊರೆ ಹೋಗ್ತಾನೆ, ಹೌದಲ್ವಾ? ಪ್ರಮುಖವಾಗಿ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಆ ವ್ಯಕ್ತಿಗೆ ಪರ್ಸನ್ ಶುಡ್ ಹ್ಯಾವ್ ಗಾಟ್ ಅನ್ ಇನ್ಹರೆಂಟ್ ರೈಟ್. ಇಫ್ ದಟ್ ರೈಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಅಫೆಕ್ಟೆಡ್, injured, infringed, then he can approach the civil court. So, the first and foremost thing, where to approach, when to approach, who has to approach, and how to approach. This is the total concept of civil procedure court. Yaru hogbeku court ke? The person who has a right inherently. Person means not any member. Yar bekadru hogodalla. A person who has affected his right shall only approach the court for redressal or remedy. Then where to approach? Elliಗೆ ಹೋಗಬೇಕು, ಯಾವ ಕೋರ್ಟ್ಗೆ ಹೋಗಬೇಕು? ಸಿ ಈ ಪ್ರಶ್ನೆನಲ್ಲೇ ನಮ್ಮ ಎಂಟೈರ್ CPs ನ ನಾವು ಕಂಡೆನ್ಸ್ ಮಾಡಬಹುದು ಅಲ್ವೇ? ಪರ್ಸನ್ ಅಂತಂದ್ರೆ ನೆಸೆಸರಿ ಪಾರ್ಟಿ, ಆರ್ಡರ್ 1 ರೂಲ್ 10, ರೈಟ್? ದ ಪ್ಲೇಸ್, ಯಾವ ಜಾಗದಲ್ಲಿ ಹೋಗ್ಬೇಕು? ಪ್ಲೇಸ್ ಆಫ್ ಸೂಯಿಂಗ್, ರೈಟ್? Who shall approach? ಯಾರು ಹೋಗ್ಬೇಕು? The person whose rights have been abridged or affected or infringed shall approach a proper forum. Proper forum means here the court which has got the jurisdiction. Jurisdiction means here the authority, the power of the court. That power conferred by the statute and the jurisdiction of varied kind. One is territorial jurisdiction and pecuniary jurisdiction. This is where you have to present the plaint. Since the C.P.C is a very vast subject now, there are 158 sections. So I have selected very few questions, very few sections which are very, very relevant for our purpose. So one of the important section is section 2 subclass 2 of C.P.C. What is section 2 subclass 2? This is very, very important. So decree. Decree indre ಏನು ಅಂತಕ್ಕಂಥದ್ದು ಮುಖ್ಯ ಅಲ್ವಾ? Every one of us have read it. It is not that it is alien to our discussion. ಇದೇನು ಹೊಸದಲ್ಲ ನಮಗೆ ಡಿಗ್ರಿ ತಿಳ್ಕೊಳ್ಳೋದು. ಆದ್ರೆ ಪ್ರತಿ ಸಲ ಓದಾಗ್ಲೂ ಕೂಡ the reading which gives the perfection. Reading and discussions makes the perfections to present. ಅದರಿಂದ ಡಿಗ್ರಿ ಮೇಲೆ ಇನ್ವೈರಬಲಿ ಪ್ರಶ್ನೆ ಬಂದೇ ಇದೆ, ನೀವು ನೋಡ್ತಾ ಇದ್ದೀರಿ. ಅದಕ್ಕೆ ಸ್ಪಷ್ಟತೆಯನ್ನ ನಾವು ಕಾಣೋಣ. ಡಿಗ್ರಿ ಅಂದ್ರೆ ಏನು? Section 2 subclass 2 ಏನ್ ಹೇಳುತ್ತೆ? It is a formal expression of an adjudication. Yes. ಬಹಳ ಮುಖ್ಯ ಏನು? It is a formal expression. Expression of what? An adjudication. Adjudication of what? An adjudication of rights of the parties. ನಾನು ಆಗ್ಲೇ ಹೇಳಿದೆ, who has to approach the court? ಯಾರು approach ಮಾಡಬೇಕು? The person who has got an inherent right. If that right infringed ಅಂತ ನಾನು ಹೇಳಿದೆ. Yes, decree means a formal expression of an adjudication of a rights, right? With regard to all or any of the matters in controversy, right? When there is a controversy with regard to the rights claimed and right denied by the other side, that formal adjudication of that right is a part of a decree. Then the second point is, such adjudication must be in a suit. Yelli, wherever, everywhere the party's right cannot be adjudicated. In a suit, right? And that adjudication must conclusively determining the rights of the parties. You got it, my friends? In a suit, the rights of the parties conclusively determines the rights and pass the decree by the court which has got competent jurisdiction. That is very important. You got the meaning of decree here. There are two kinds of a decree. One is preliminary decree and the other is the final decree. What is preliminary decree? See, in a partition suit, only the rights which is already within the parties has been determined. See, determination of the rights is one thing, and put them in physical possession after drawing the final decree is the other. So deciding the rights of the party of their respective shares after adjudication is a preliminary decree. And putting them in separate possession by a final decree. So now we got the concrete meaning of a decree. Decree means a formal expression of an adjudication of the controversy between the parties in a civil suit which has got a competent jurisdiction to decide. The decree are of two kinds. One is preliminary decree and final decree. So decree is very, very clear now. Now I will take you to the next point, whether a suit is dismissed for default. One suit default dismiss agirtade. Can we call it as a decree? No. Why? Because no adjudication has been taken place in a decree for dismissal. Right? Yes. When a plaint is rejected under Order 7 Rule 11A, B, C, D, how do you treat that? Absolutely, it's a decree. Because a dismissal, a plaint is dismissed after adjudication, whether he has got right or not, whether there is a cause of action or not, whether the subject matter is amenable to that jurisdiction or not, then it is a decree. Yes, now I will take you only relevant points which I have culled out from the question papers. Next, I will take you to legal representatives. It's very, very important. See, in a suit, in a pending suit, pending between the parties, that is the plaintiff and the defendants. During the pendency of the suit, either the plaintiff, one of the plaintiffs, or either one of the defendant dies during the pendency. What is the effect of that suit when one of the plaintiff dies? If one of the plaintiff dies during the pendency of the suit will abet against him. The proceedings will be terminated against him. In such a circumstances, how to move about and who has to continue the proceedings? See, the proceedings will not be terminated upon death of one of the plaintiffs, where there are more number of plaintiffs. The suit will not be terminated if one of the defendants dies where other defendants are available for prosecution, for continuation. So now, if one of the parties dies during the pendency, either the plaintiff or the defendant, the Civil Procedure Code provides the remedy under Order 22 Rule 3 C.P.C. One has to bring the legal representatives on record. Who is a legal representative for the purpose of contesting or continuing the suit? Yaru legal representative. It is not every members of the family. It is not every dependents of the family. It is not every relatives of the family would become the legal representative for the purpose of continuing the proceedings. Therefore, the law recognizes as to who shall be the legal representative. Order 2 Rule 11 C.P.C. says legal representative means a person who in law represents, not otherwise, the person who in law represents the estate of the deceased person and includes any person who intermeddles. See, this is very, very important. Now, ಯಾರ್ಯಾರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಒಂದು ಪ್ಲೇಂಟಿಫ್ ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ನ ತೀರ್ಕೊಂಡಾಗ ಆ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡ್ತಕ್ಕಂಥ ಅಗತ್ಯ ಇಲ್ಲ ಅಥವಾ ಮಾಡ್ಲಿಕ್ಕೂ ಬರಲ್ಲ. ಕಾರಣ ಲಾ ಸ್ಪೆಸಿಫೈಸ್ as to who is a representative under section 2(11) of CPC. Who is a legal representative for the purpose of continuation of the proceedings? He is a person. Illi person anta padana nan balastene. Person means he or she. He may be plaintiff or the defendant. He may be the LR of the plaintiff or the LR of the defendant. A person in law, right, represents the estate of the deceased person, in law, he shall continue the proceedings, not otherwise. You got the point. Legal representative concept ನಿಮಗೆ ಗೊತ್ತಾಯ್ತಲ್ಲ? A person in law entitled or to succeed the estate of the deceased person alone can be treated as the legal representative for the purpose of continuation of the proceedings upon the death of one of the legal plaintiff or upon the death of one of the defendant in a suit for proceedings. And one more person is legal representative is in-law ಆಯ್ತಲ್ಲ. ಇನ್ಯಾರು ಅಂತ ಹೇಳಿದ್ರೆ a legatee under a will is also a legal representative who could truly and substantially represent the estate of the deceased, who could represent the estate, who could succeed the estate. Estate here means the assets as well as liability. ಇಲ್ಲಿ ನೋಡಿ, estate the profit ಅಷ್ಟೇ ಅಲ್ಲ. What has been left by a party? He might have left the immovable property. He might have left the liability clothed or attached on the immovable property, become the legal representative for the purpose of gaining and discharging. That is one part of legal representative. And the second part of it is a legatee. Who is a legatee and what is the will is one of the point. At this stage only we can discuss. This is a definition class ಆಗಿರೋದ್ರಿಂದ. So legatee means the beneficiary under a will. Alva. What is a will here? Will, ಉಯಿಲು ಅಂತ ಕರಿತೀವಲ್ವಾ ಕನ್ನಡದಲ್ಲಿ. ಇನ್ನೊಂದು ಮರಣ ಶಾಸನ ಅಂತ ಕರಿತೀವಿ. ಇಲ್ಲಿ ನಾವು ಎಕ್ಸಾಸ್ಟಿವ್ ಡೆಫಿನೇಷನ್ ಬೇರೆ ಸಬ್ಜೆಕ್ಟ್ಸ್ ನಾವು ತಿಳ್ಕೊಂಡಿದ್ದಾಗ ಮಾತ್ರ ಅಟ್ ಅನ್ ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಟೈಮ್, ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ಅದನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯವಾಗ್ತದೆ. See, will is a testamentary document. Under section 2 subclass H of the Indian Succession Act 1925 defines will. Will is the legal declaration of an intention of the testator that upon his death of the testator, that right in that property shall go to him after his death. So this is different from that of a Transfer Property Act, whereas the sale is different from that of will. What is the necessity of here to explain the will and that of a sale? Because if we go to plead in the plaint seeking the relief, what we have to plead another ಬಗ್ಗೆ ಇಲ್ಲೇನೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಏನನ್ನ ಪ್ಲೀಡ್ ಮಾಡಬೇಕು? What is your case ಅನ್ನೋದ್ರ ಬಗ್ಗೆ. See, in a sale, a transfer of an interest or ownership or possession in an existing immovable property by one person to the other for a consideration paid or agreed to be paid at a later stage is a sale. Sale is a transfer intra vivas between the parties. The transfer between the living persons, whereas the will is different. Will is a testamentary document. The intention will be carried out after the death of a testator to the beneficiary. So therefore, the legal representative, how to connect the legal representative with this definition ಅಂತ ಹೇಳಿದ್ರೆ, an estate is being under challenge, estate being disputed. In that situation, if one of the parties claim the estate is died, then the person in law represents the estate, is a legal representative, and he has to come on record within a given time. And the legatee of a will can also be party to the pending proceedings because the cause of action survives against the person. ಇಲ್ಲಿ 3 points legal representative. This is very important. ಯಾವುದೋ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಅದನ್ನ ತೀರ್ಮಾನ ಮಾಡಕ್ ಬರಲ್ಲ. ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಅಂತ ಬಂದಾಗ್ಲೇನೆ ನಾವು ಡೆಫಿನೇಷನ್ ಕ್ಲಾರಿಫೈ ಮಾಡಬೇಕು. ರೈಟ್? ಎನಿಬಡಿ ಕೆನಾಟ್ ಬಿ ಎ ಪಾರ್ಟಿ. ಇಟ್ ವುಡ್ ಬಿಕಮ್ ಎ ನಾನ್ ಸೂಟರ್ ಆಗ್ತಾರೆ. right? Unnecessary party ಆಗ್ತಾರೆ. ಅವಾಗ್ಲೇನೆ ನೀವು order 1 rule 10 who is a necessary party, who is a proper party, ಇದೆಲ್ಲ ಪ್ರಶ್ನೆ ಬರುತ್ತೆ. See, unless he is a essential party, he is a necessary party, if he is a proper party, no parties can be on record. You see, no suit to be continued against him. Why shall he make a party? The court has power at any stage to delete the unnecessary parties and to include the necessary and proper parties. Therefore, the concept of legal representative is very, very important for the purpose of our discussions. Yes, now it is very clear as to who is the legal representative and a decree, right? Next, I will take you to the very important section, that is section 9 of C.P.C. What is section 9 of C.P.C speaks about? This is very interesting and important because place of suing and the civil court anta nan balasta illi, civil procedure code invariably civil court al applicable agutte. See, section 9 speaks jurisdiction of the civil court. It is the civil court has got the jurisdiction to entertain all suits of civil nature unless their cognizance is either expressly or impliedly barred. What do you mean by this? It is a general power. The statute confers an exclusive jurisdiction to the civil courts to entertain and to try all civil suits except impliedly or expressly barred. Place of suing and the jurisdiction of the court ಬಗ್ಗೆ ನಾವು ಮಾತಾಡ್ತಾ ಇದೀವಿ. Section 9 is very, very important section for understanding and for practical purposes and for academic purposes and for the aspirants also. Sometimes on the question of maintainability, on the question of jurisdiction of the suits, number of suits can be disposed of and dismissed at the threshold itself. Ega, a general power, a general scope has been given to civil courts. All suits are to be entertained and to be disposed of by the civil court, except otherwise barred by any other statute. For example, a suit for possession, a suit for injunction, a suit for declaration, a suit for partition, a suit for recovery of money, are within the exclusive jurisdiction of the civil court to entertain and to declare and to grant relief as so far. Right? For example, the law is advanced to have an expeditious relief. Certain tribunals have been formed now. Arbitration is in the vogue. Right? In case of a money suit, money recovery suits, the C.P.C is amended in 2002. If the value of the property exceeds 10 lakhs, the bank or any financial institution have an alternative and efficacious remedy. This is very, very important. When a civil court is barred to entertain the suit, if a party has got an alternative and efficacious remedy under any other law for the time being in force, can invoke the special jurisdiction, that is DRT, has been provided. The tribunal, see, debt recovery tribunal constituted in order to have an expeditious relief to the banking institution in case of recovery of loan. Right? That is one exclusion of jurisdiction. Civil court bar is the impliedly bar and expressly barred. So I'll give you another example of what is in case of a dispute with regard to the employer and employee, right? Workman and employer in relation to the payment of salary, arrears of salary, and the terms of appointment and terms of retrenchment, terms of service benefits, where the industrial tribunal and the labor court has provided to vindicate their grievances according to the particular statute. The industrial dispute is all the cases relating to the dispute with regard to the employer and employee, the terms of employment, the terms of service benefits, the terms of retrenchment, the terms of retrenchment benefit. All these cases has to be decided by the tribunal court under the Industrial Dispute Act and under the Workmen's Compensation Act. So therefore, the civil court is barred in entertaining such proceedings, such eventualities. That is second aspect. Whereas in case of the dispute with regard to the Cooperative Societies Act, right? Section 70 of the Cooperative Societies Act provides for the raising of disputes in respect of if there is a dispute with regard to the management and the business that the cooperative society is carrying on, the civil court cannot. It is the aggrieved parties can raise a dispute before the registrar of cooperative societies to vindicate such grievances of the parties. Then also the civil court is barred. For example, when a state through his agency wants to acquire the land for the public purpose and notify the private parties land for the acquisition of for the public purpose by notifying a gazette in the official gazette, right? Section 4.1 of the Karnataka Land Acquisition Act and 6.1 of the Act, and award notice has been passed. In that circumstances, the acquisition proceeding cannot be challenged by the party in a civil court because the remedy is elsewhere under the particular Karnataka Land Acquisition Act or now the Fair Compensation Act of 1913. 2013 only was Act for the Fair Compensation Act. So, if an alternative and efficacious remedy available to the party to vindicate their grievances in a different forums, civil court is barred. In all such circumstances, every suit of civil nature, only the civil court has jurisdiction. I think we have clarified insofar as this aspect is concerned, right? All suits except barred under law. The clarity is most important and consistency. Yes, I'll give one important judgment on that point of the bar of civil jurisdiction. Rudrappa versus Rajeshwari, 2007 bracket 4 KCCR 2756. If you go to this judgment when you are free, you can know what is the, yes, friends. Next, I will take you to section 10 and section 11 are very, very important sections for you. Yes. Well, friend, what is section 10? It has suit of the definition class. So then we will go to the plaint and other things. What is section 10? Now we have already discussed about the place of suing, right? Section 10, section 11, section 2 subclass 2 are synonymous each other. The ingredients in all these sections are similar, except some of the deviated ingredients we can identify and to segregate. Well, friends, now I will take you to section 10. What section 10 speaks about? See, the parties have filed a suit for declaration and possession in one court to redress their infringement of their civil right. That court has competent jurisdiction to try. Similarly, in a concurrent jurisdiction, the defendant has filed another suit in a different court in different part of the country, right? In respect of the very same subject matter, fact and issue, in respect of the very same subject matter between the same party, right? In a court of competent jurisdiction to try. Whether in a circumstances, if the fact of pendency of another suit between the same parties in a competent jurisdiction in respect of the very same subject matter is brought to the notice of the former court. See, I would like to explain former suit and a subsequent suit. Former suit in a competent court which has got jurisdiction to try is pending between the same parties in respect of the subject matter, right? Is pending consideration. Similarly, in any one of the courts in the country is also pending between the same parties in respect of the very same subject matter and in respect of the very nature of the relief is also pending. In such a circumstances, whether the two suits simultaneously be continued or one of the suit shall be stayed is the question. Our answer is yes, one of the suit shall be stayed. Why? The very interesting point is why another suit has to be stayed. Because in case of an identical issue, required to be determined by the very same court which has competent jurisdiction to try, the subsequent suit is required to be stayed. The purpose being, in order to avoid abuse of process of law, in order to avoid the expenses, and in order to avoid the time to be spent by the court, that is called the judicial time, and also by the parties, stay has to be passed by the court, staying the further proceedings in the subsequent suit. And the most important object of staying the subsequent suit is for the purpose of avoiding the conflicting decision in both the cases. This is very, very important. Why it has to be stayed? To avoid the conflicting decision in two suits. A judicial discipline is most important in this area, right? ಸೇಮ್ ಸೂಟ್ ಅಲ್ಲಿ ಒಂದು ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ತೀರ್ಮಾನ ತಗೊಂಡು ಇನ್ನೊಂದು ಕೋರ್ಟ್ ನಲ್ಲಿ ಇನ್ನೊಂದು ತೀರ್ಮಾನ ತಗೊಂಡ್ರೆ ಎಂತ ಆಘಾತ ಆಗುತ್ತೆ. ಡಸ್ ಇಟ್ ನಾಟ್ ಅಫೆಕ್ಟ್ ದ ಜುಡಿಷಿಯಲ್ ಡಿಸಿಪ್ಲಿನ್? ಅಪಾರ್ಟ್ ಫ್ರಮ್ ಬಿಯಾಂಡ್ ಕಾಸಿಂಗ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸಸ್, ಲಾಸ್, ದ ವೇಸ್ಟ್ ಆಫ್ ಟೈಮ್ ಅಂಡ್ ದ ಜುಡಿಷಿಯಲ್ ಟೈಮ್, ದ ಮೋಸ್ಟ್ ರೆಲೆವೆಂಟ್ ಆಬ್ಜೆಕ್ಟ್ ಫಾರ್ ಸ್ಟೇಯಿಂಗ್ ಆಫ್ ಎ ಸೂಟ್ ಈಸ್ ಟು ಅವಾಯ್ಡ್ ದಿ inconsistency in decision, right? This is very, very important aspect of the stay of suit. In one of the case which I am giving you now, AR 2004 SC 2339, the Honorable Supreme Court has held that avoidance of possibility of conflicting decrees is the object of section 10 to stay the earlier suit. This is section 10. This is also called sub judice anta karitare. Nimge sub judice andre enu, res judicata andre enu, the differences enu, meaning of these two terms enu antadalli because ಪ್ರಶ್ನೆಗಳು ರಿಪೀಟ್ ಆಗಿದಾವೆ. ಆದ್ರಿಂದ section 10 and section 11 of C.P.C are very important and relevant for our discussion for the purpose of examination point of view. So I think section 10, section 9 is very much clear, and section 10 is also very much clear. Now let's go to section 11 for to have a clarity. And ಇಲ್ಲಿ section 10 ಮತ್ತು 11 ಗೆ identical elements idave. Certain ingredients or elements of section 10 and 11 are very identical. Only difference enu section 11 gu matte 10 gu, matte what is the important fact determined in section 11 and section 10 ಅನ್ನೋದನ್ನ ನಾವು ಕ್ಲಾರಿಫೈ ಮಾಡ್ತಾ ಹೋಗೋಣ. Section 11 ಏನ್ ಹೇಳುತ್ತೆ? You are very familiar with section 11 of C.P.C, that is res judicata. Well friends, what is res judicata? ಈ section 11 ನಲ್ಲಿ invariable ಆಗಿ ನಿಮಗೆ questions ಬಂದಿದೆ. Let us go in detail about section 11. Section 11 reads thus: in general means a thing adjudicated, no court shall try any suit or issue. You please make it a point. No court shall try any suit or issue which the matter is directly and substantially in issue in a former suit between the same parties or under them, or any of them or all of them under the same title, in a court of competent to try such issue subsequently raised or same issue raised, heard and finally decided by such court. Yes, now I will explain you. ಈಗ in section 10 ನಲ್ಲಿ ಏನ್ ಸಿಮಿಲಿಯಾರಿಟಿ ಇತ್ತು, ಒಂದೇ ಫ್ಯಾಕ್ಟ್ಸ್ ಐಡೆಂಟಿಕಲ್ ಇದ್ದಿದ್ದೇನು section 10 ಅಲ್ಲಿ and section 11 ಅಲ್ಲಿ ಏನ್ ಐಡೆಂಟಿಕಲ್ ಆಗಿದೆ ಇಶ್ಯೂಸ್, and what is the difference between section 10 and 11? ಇವೆರಡೂ ಕಂಪ್ಯಾರಿಟಿವ್ ನಾವು ಸ್ಟಡಿ ಮಾಡಿದಾಗ ಐಡೆಂಟಿಕಲ್ ingredients and the difference now ಕಂಡುಕೊಂಡಾಗ then we can able to place our view properly. So in section 11 ನಲ್ಲಿ an issue which is directly substantially decided by the competent court of law having jurisdiction to decide between the same parties shall not be decided by another court in respect of the very same fact in issue, which has been decided by the earlier case. Andrenu section 10 gu idku enu similarities and distinctions that we have to draw. What are the similarities? Suit filed, 2 suits for file, right? One is former and the subsequent suit. In section 11 also, there must be suits, 2 suits. And the next point is, and those suits in respect of the very same subject matter, right? And those 2 suits are pending before the very competent court having jurisdiction. And thirdly, the subject matter of the suit is identical with that of the 2 suits, right? So now let us have the distinction between section 10 and 11. Only the distinction is, in section 10, both suits are pending consideration when the former suit, in a former suit, subsequent proceedings of the suit will be stayed, whereas the only difference between section 10 and 11 is, in this case, in a former suit, an issue directly and substantially pending before the court between the same parties as finally and directly, substantially has decided on merits, cannot be tried and decided in a subsequent suit. This is the concept of section 11. ಅಂದ್ರೆ ಒಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಬ್ಬರು ಪಾರ್ಟಿಗಳು ಇದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ ಆ ಒಂದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಒಂದೇ ಇದ್ದಾಗ ಕಾಂಪಿಟೆಂಟ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಕೋರ್ಟ್ ಫೈನಲ್ ಆಗಿ ಅಂತಿಮವಾಗಿ ಆ ಇಶ್ಯೂನ ಅಡ್ಜುಡಿಕೇಟ್ ಮಾಡಿ ಒಂದು ಡಿಕ್ರಿಯನ್ನ ಪಾಸ್ ಮಾಡಿದಾಗ ಅದೇ ಪಾರ್ಟಿಗಳು ಅದೇ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಬಗ್ಗೆ ಇನ್ನೊಂದು ಕೋರ್ಟ್ ನಲ್ಲಿ ಸೂಟ್ ಹಾಕಿ ಪರಿಹಾರವನ್ನ ಕೇಳ್ತಕ್ಕಂಥದ್ದನ್ನ ನಿಲ್ಲಿಸಬೇಕು ಅಂತ. ಪರಿಹಾರ ಕೊಡ್ಲಿಕ್ಕೆ ಆ ಕೋರ್ಟ್ಗೆ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಇರಲ್ಲ, ಮತ್ತೆ ಪಾರ್ಟಿಗಳಿಗೆ ಅಧಿಕಾರನೂ ಇರಲ್ಲ ಅಂತಕ್ಕಂಥದ್ದು ದಿ ಸ್ಕೋಪ್ ಆಫ್ ಸೆಕ್ಷನ್ 10 ಆಫ್ ಸೆಕ್ಷನ್ 11 ಆಫ್ ದಿ ಕೋಡ್ ಆಫ್ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್. ಇದಕ್ಕೆ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಕೇಸ್ ಅನ್ನ ಕೊಡ್ತೀನಿ. ಸೆಕ್ಷನ್ 2008 ವಾಲ್ಯೂಮ್ 4 KCCR 2619. Yes. Then I will take you to section 75. Section 15, 16 and 20 ಹೋಗೋಣ. Jurisdiction of the court. This is very important alva. Place of jurisdiction ಅಂತ, ಪ್ಲೇಸ್ ಆಫ್ ಸೂಯಿಂಗ್ ಅಂತ ನಾನು ಫಸ್ಟ್ ಹೇಳಿದೆ ನಿಮ್ಗೆ. ಎಲ್ಲಿ ಯಾವ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸ್ಯೂ ಮಾಡಬೇಕು, ಪಾರ್ಟಿ ಹ್ಯಾಸ್ ಟು ಅಪ್ರೋಚ್ ವಿಚ್ ಕೋರ್ಟ್, ಇಟ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ದಿ ಪೆಕ್ಯುನರಿ jurisdiction of the court, territorial jurisdiction of the court, territorial jurisdiction, pecuniary jurisdiction and other jurisdiction ಅಂತ ಬರ್ತದೆ, and the nature of the relief that they are seeking. Right? In all suits, invariably, in a case of suit for bare injunction, the party shall approach the lowest court of the jurisdiction. Right? Because in an injunction suit, whatever the value of the property, market value of the property, you will calculate the jurisdiction for the purpose of relief. That is injunction suit section 26C ನಲ್ಲಿ ನೀವು suit ನ ವ್ಯಾಲ್ಯೂ ಮಾಡ್ತೀರಿ. Therefore you can select the lowest jurisdiction of the court. Yes, that is section 15. Section 16, if the pecuniary jurisdiction is higher, then you can select the next senior civil judge. You can select for the declaration and for injunction and for possession. And section 17, if the properties in respect of an immovable properties, more than one property, if one property is existing in one of the jurisdiction of the court and other property is situated in other jurisdictions, you can select either of the two courts which has got jurisdiction. In that circumstances, both courts have a concurrent jurisdiction to try. So then the party can select at his convenience. A property situated in Bangalore, immovable property, a property situated in Belgaum, another immovable property, either he can choose the jurisdiction of the Bangalore or jurisdiction of Belgaum. That is the import of section 17 of the Act. There is one principle called the plaintiff being a dominus litis can file a suit only at one or the other places specified in C.P.C. and not any place as he desires. One decision ಕೊಡ್ತೀವಿ. Mohan Kumar Naidu versus Vijay Kumar Naidu, 2007, bracket 12 SCC 130. Plaintiff is the dominus litis. It is at his convenience he can file only when it is permissible. When it is permissible, if the immovable property situates in more than one of the jurisdiction of the court, then he can select either of the two. Not in all cases. Right, that is section 15, 16 is very a small question. Yes, friends. Next, I will take you to chapter 3, section 75. Illi, we will have to little slow in understanding. The Civil Procedure Code provides for 3 branches to be studied, 3 branches to understand. The one of the important branch is there are 3 kinds of proceedings. One is an incidental proceedings, right? Incidental proceedings and special proceedings and supplementary proceedings. These 3 areas of a civil procedure, you can identify whether this is an incidental proceeding or a special proceedings or a supplementary proceedings. Within 3 paradigms, civil procedure now suit na institute madakagadu. Right? What are incidental proceedings? Section 75 speaks about incidental proceedings. That is, court may issue commissions. Alva, ivella incidental to that of main proceedings. Okay. Main proceedings is to award the decree, adjudication of the controversy in issue. That is the main purpose. In order to reach that final decree, the court has to undergo number of incidental proceedings. The party can invoke the procedure to achieve the object of decree, achieve the object of obtaining the decree. Section 75 provides, right, an incidental proceedings like appointment of a commissioner. What are the purposes for which the court may appoint the commissions? The first and foremost and immediate purpose is to examination of witnesses. See, after the pleadings are completed, issues have been framed, trial to begin. Always, these are the regular proceedings in a civil court. when plaintiff is examined personally or through a power of attorney holder, he wants to examine the witnesses. That witness may aged, ailing, unable to appear before the court, or that witness may be an official witness who cannot appear before the court for obvious reasons. In that circumstances, court may appoint the commission at the request of the parties concerned. The plaintiff may file an application requesting the court to appoint an advocate commissioner to visit the place of the witnesses and to record his evidence and to submit before the court. This is very, very important procedural aspect. This is an incidental proceedings ಅಂತ ನಾವು ಕರಿತೀವಿ. ಇದು ನಾವು ಅಕಾಡೆಮಿಕ್ ಪರ್ಪಸ್ ನಾವು ಹೋದಾಗ ಇವೆಲ್ಲ ನಾನು ಸರ್ಚ್ ಮಾಡಬೇಕಾಯ್ತು. ಅಂಡ್ ಇಟ್ಸ್ ವೆರಿ ರೆಲೆವೆಂಟ್, ರೈಟ್? ಎಸ್. ಒಂದು, the witness, a commission was appointed by the court to examine the witness and submit the deposition before the court. That is subject to scrutiny and cross-examination by the other party. That's one thing. And secondly, to make a local investigation. This is very, very important. In local investigation, ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಮಾಡ್ತಾರೆ? ಆರ್ಡರ್ 26 ರೂಲ್ 9 CPC ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ದ ಕಮಿಷನರ್ ಅಂತ ನೀವು ಕೇಳ್ತೀರಿ. ಈಗ ಇದು ಸೆಕ್ಷನ್ಸ್ ಮತ್ತೆ ಆರ್ಡರ್ಸ್ ಅಂಡ್ ರೂಲ್ಸ್ ರಿಲೇಟೆಡ್ ಆಗಿರ್ತದೆ. ಇನ್ಸಿಡೆಂಟ್ ಪಿಟಿಷನ್ ಇನ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 75 ನೋಡ್ಕೊಂಡ್ರೆ ನಾವು ಇಮಿಡಿಯೇಟ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಟು ಸೆಕ್ಷನ್ 26 ರೂಲ್ 9 CPC. ಎಂತೆಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಆಗ್ತಿರೋದು? ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಎ ಕಮಿಷನರ್ ಫಾರ್ ದಿ ಲೋಕಲ್ ಇನ್ಸ್ಪೆಕ್ಷನ್. When if there is a dispute with regard to the identification of the property. First of all, dispute with regard to the existence of the property, dispute with regard to the identification of the property, of its extent or measurement, dispute with regard to the existence of the building or not, dispute with regard to the existence of a tank there or not, dispute with regard to the existence of a public road or not, right? In such various conditions, if there is a doubt arises to the mind of the court based on the pleadings, the court can either take suo cognizance of the fact and to satisfy itself as to whether about the existence of certain things, right? Certain fact and I would like to employ the word fact here. A dispute with regard to the existence of the fact and the nature of the fact. Then to have a clarify and to satisfy by the court about its existence or non-existence. Then upon an application made by either parties to the proceedings or suo motu, the court may appoint the commissioner for local investigation. Illi fact another relevance alva. Nan order 7 rule 1 plaint ಅಲ್ಲಿ ಹೇಳಬೇಕಾದ ಫ್ಯಾಕ್ಟ್ ಹೇಳ್ತೀನಿ. ಇಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ ಅಂತ ಬಂದಾಗ ಬಹಳ ಮುಖ್ಯವಾಗಿ ಕೋರ್ಟ್ suo motu cognizance ತಗೊಳ್ತಾರೆ. ಇದನ್ನ disputed fact. ಏನ್ ಫ್ಯಾಕ್ಟ್ ಅಂದ್ರೆ ಏನು? Fact has not been defined in CPC, but we have to go to the Evidence Act to know the fact. Section 3 of the Evidence Act states fact means anything, state of thing, relation to the things which is capable of pursuing by the senses of a person. Secondly, the mental condition of a person is a fact. Look at the beauty of the explanation of the fact in Evidence Act. Evidence Act is also an adjective procedure which I've expressed in the previous occasions when we are discussing about. So there is a fact in dispute, right? Which has a disputed the claim in respect of the fact or existence of one person say there is a fact, existence of a tank in that land. Existence of a public road anತಾರೆ. See, when the public interest is exposed by the parties before the court has to take sumo proceedings to identify and to find out the existence of the fact. Then an appointment of a commissioner. Ili section 75 ಮತ್ತೆ 26 ಅಲ್ಲಿ simultaneously question ಬರ್ತಿದೆ, repeat ಆಗ್ತದೆ. Therefore I am little concentrating on this section. Incidental proceedings ಬಹಳ ಮುಖ್ಯವಾದ್ದು. ಹಾಗಾಗಿ ನಾನು ಇಲ್ಲಿ ಹೆಚ್ಚಿಗೆ ಒತ್ತನ್ನು ಕೊಡ್ತಾ ಇದ್ದೇನೆ ಈ ಸೆಕ್ಷನ್ಗೆ. ರೈಟ್, ಯಾವ ನಂಬರ್ ಆಫ್ ವೇರಿಯಸ್ ಕೈಂಡ್ಸ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ಯಾವುದಿದೆ? ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ ಲೋಕಲ್ ಇನ್ಸ್ಪೆಕ್ಷನ್. ದೆನ್ ಇದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಎ ಕಮಿಷನರ್, ಅಡ್ವೊಕೇಟ್ ಕಮಿಷನರ್ ಆಗ್ಬೋದು ಅಥವಾ ಎನಿ ಅಫಿಷಿಯಲ್ಸ್ ಆಗ್ಬೋದು. ಲೋಕಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಒಂದು. ಇನ್ ಕೇಸ್ ಆಫ್ ಎ ಡಿಸ್ಪ್ಯೂಟ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಮೆಜರ್ಮೆಂಟ್ and to find out the nature of the property, whether the property is an agricultural property or a converted property or a forest land or a government land or such other properties, then the court may appoint the ADLR. Public servants can be appointed. ADLR andre Additional Director of Land Revenue, Land Records. ADLR is the right person to measure and fix the boundary. Measurement ಮಾಡಿ boundary ಇದೆಯಾ ಅನ್ನೋದು fact, disputed fact. He can measure and submit the report with the existing boundaries to that to identify whether that fact exists or not. Local investigation only. And then yet another important aspect is an expert evidence has to be appointed. ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ? When a signature in a will is disputed, when a signature in a sale deed is disputed, in that circumstances, handwriting expert, right, will be appointed for the purpose of examining and give a report as to the genuineness of the signature or the thumb impression of a party who has executed that document. Then, yet another important, after the decree, preliminary decree and final decree ಅಂತ ನಾವು ಹೇಳಿದಲ್ಲ, in a partition suit, ಈಗ ಏನ್ ಮಾಡ್ತಾರೆ ಈಗ under section 54 of the C.P.C, after the decree of partition is made, then to make a partition, to measure the land and put in separate possession of the property, avaglu commission appoint ಮಾಡ್ತಾರೆ. All right, in one of the case, nande personal case ಅಲ್ಲಿ, when a partition is effected, rights have been determined. Each one of the parties have got 1/4 share in the determined that the property is only one property. It is a building. The building cannot be demarcated practically. So in that case, the sale of the property is the only option. In such a circumstances, the commission has to be appointed to find out whether the sale is only option, and if so, what could be the value of the property to be assessed and give a report to that for the purpose of permitting to public action. So this is one such area where incidental property. Then to make a scientific and technical report, scientific and technical report public depends on the nature of the source, and to conduct a sale also, subsequently sale has to be conducted. Under that circumstances, the commission will be appointed by the courts. So this is very, very relevant. Section 75, incidental proceedings. That 75 has to be read along with order 26, rule 9 of Code of Civil Procedure. Then the next, I will take you to section 79. 79 is very important section also, because all that we have discussed about the suits between the private parties. Now, when a suit is required to be filed against the state or its agencies, when I was the government advocate, have an occasion to deal with the suits by the government and suit against the government and the government agencies. Section 12 of the Constitution of India speaks about what is a state. State and the definition that's not required for now. And the state agencies. Yes. When a suit is to be filed against the state, what are the requirements to be followed by the parties? Either sue or be sued. ಈಗ ಸ್ಟೇಟ್ ಮೇಲೆ ನಾವು ಕೇಸ್ ಹಾಕ್ಬೇಕಾಗಿದೆ, ಯಾವ ಪ್ರೀ ಕಂಡೀಷನ್ಸ್ ನಾವು ತಗೊಳ್ಬೇಕಾಗ್ತದೆ, ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ, ಇದು ನೋಡಿ ಹೌ ಪಾರ್ಟೀಸ್ ಇಸ್ ಎ ರೆಲೆವೆನ್ಸಿ ಅನ್ನೋದಕ್ಕೆ ನಾನು ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಸೆಕ್ಷನ್ 211 ನಲ್ಲಿ ಡಿಸ್ಕಸ್ ಮಾಡುವಾಗ ನಾನು ಕ್ಲಾರಿಟಿ ಕೊಟ್ಟೆ. ಹೂ ಇಸ್ ಎ ಪಾರ್ಟಿ ಟು ಎ ಪ್ರೊಸೀಡಿಂಗ್ಸ್? Who is a party? It is not the person, it is not the member. In a civil society, before a civil proceedings, before a civil court, party means a person who has a right to enforce and the person who has a right to defend, right, should have an inherent right to enforce or inherent right to defend. Is a party to the proceeding. That you have to understand while pleading, while making the parties. When, if we want to sue the central government, who is a necessary party? The central government is a necessary party. The Union of India, anta ನಾವು ಬರೀತೀವಿ. Union of India ಬರೆದರೆ ಸಾಲದು. That Union of India has to be represented by whom? The Chief Secretary. And if the Union of India represented by different departments, the Secretary of that department, Union of India antale ನಾವು ಕೇಳಿದಾಗ, then necessarily the Chief Secretary. And other departments ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, Finance Department, Finance Secretary, Revenue Department, Revenue Secretary, Income Tax Department, Commissioner of Income Tax, Chief Commissioner of Income Tax. ಹಾಗೆ say legal entity ಬೇರೆ, representative of that legal entity is the other things. One must represent the entity. Suppose in case of railway ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, no doubt it's covered under the union list, union government. The railway must be represented by the general manager ಅಂತ ಹೇಳ್ತಾರೆ. That is the maintainability of the suit. If the suit is not properly represented by a proper person, that is where we must see in Order 1 Rule 10 ನಲ್ಲಿ who is a proper party and who is a necessary party. If this is the right place that I should examine and to plead that who is a necessary party in case of a state, so also who is a necessary and property party in case of a civil proceedings between the third parties, right? So we should not take casually anything. Necessary and proper parties are to adjudicate the rights of the parties effectively and conveniently, right, without affecting the rights of other parties. That is where making of a party in a case to be sued against the government. So these are all the proper parties for the purpose of adjudication. Section 75. Next, friend, section 80 C.P.C is very, very important. You know, to maintain a suit against the state by a third party, right? So who is the necessary party? ಇಲ್ಲಿ again state government ಅಂತ ಬಂದಾಗ, union government ಬಂದಾಗ ಅವರಾದ್ರು, state government ಬಂದಾಗ usually state government represented by the chief secretary and the revenue secretary and all. Okay. So no suit is maintainable against a state unless prior 2 months notice is issued to them, calling upon them to resolve the dispute anticipated to be redressed by a party before the court. In concept is in case a third party claims certain rights in the administrative side of the state and also the executive side of the state and also in practical side of the state. Rajya Sarkarada Viruddha administrative side agli, executive side agli, athwa procedural type agli, certain rights na ivaru claim ಮಾಡ್ತಾರೆ. Right? Yavaga, if the state wants to take the possession of the property of a third party without notice to him, in that circumstances, the party anticipating the danger of illegal taking the possession by the state, then he can issue notice to the state government saying that I am claiming the ownership which I have got this property by virtue of a grant by the very state through his agencies under a grant certificate. The grant was recognized by the revenue authorities and the mutation was effected, and the RTC also stands in my name, and I have been in possession of it and constructed a house. Don't demolish the building existing and residing herein illegally in the. The purpose of issuing a prior notice against the state government is to vindicate its grievances before resorting to its relief before the civil court. That is one of the wonderful wonderful provision made, a beneficial proviso that was provided to a civil litigant against the state. Again, the state may be alert through their agencies. Yes, they can examine the rights of the parties by making a preliminary inquiry. And if it is satisfied, then the government or its agencies stop the further proceedings. ಮುಂದಿನ ಪ್ರಕ್ರಿಯೆಗಳನ್ನು ನಿಲ್ಲಿಸಲಿಕ್ಕೆ ಅವಕಾಶ ಆಗುತ್ತೆ. ಹೌದಲ್ವಾ? Yes, we have thought of going a wrong procedure against a right person ಅಂತ ಹೇಳಿ, they can drop the proceedings against the individual to take the possession of the property, to enable the authority to reconcile themselves and to satisfy themselves about the rights of the parties accrued in the property and to drop the further proceedings. Notice is mandatory in the. This is very interesting and important. There are twin purposes here. There are twin purposes behind this proceedings. ಈ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಎರಡು ಪ್ರಮುಖವಾದಂತಹ ಉದ್ದೇಶಗಳಿದ್ದಾವೆ. ಒಂದು, to curtail unnecessary and expensive litigations. ಬಹಳ ಮುಖ್ಯ ಇದು. The object of civil procedure code is to provide an opportunity and to prevent the abuse of frivolous and vexatious litigations. ಹೌದಲ್ವಾ? ಬಹಳ ಮುಖ್ಯವಾದ ಅಂಶಗಳಿದು. ಒಂದು, to prevent and to protect the person from litigations. ಅಲ್ವೇ? ಸೊ ಆ ನೋಟಿಸ್ ಅಲ್ಲಿ ಎರಡು ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗುತ್ತೆ. ಒಂದು, government can be alert and to stop the proceedings further and to prevent the abuse on the private party who is in possession of it. It is to subserve the twin purpose of this. Section 80 of C.P.C provides proviso made to alert and to enlighten the respective parties. before to take further action in the matter. Yes, this is the reason a prior notice was required to be given to the government and this agency. Yes, next. In case if such a notice, without such a notice, if a suit is filed, whether such suits are maintainable? No. Suit is not maintainable for want of compliance of a statutory requirement. Then in case of an urgency, how the civil remedy can be availed or redressed? Again, the very same section provides, section 80 sub clause 2 of C.P.C provides dispensation of issuance of notice to the state. A dispensation application akadre, the court will entertain such dispensation application and to maintain the suit. But by mere filing a dispensation application, the party will not entitle for an ex parte order of injunction. Adu mandatory requirement of issue of prior notice and a dispense ಮಾಡಬಹುದು ವಿನಕ ex parte order of temporary injunction will not be granted. Right? Notice is a must. That is one such important section in section 79 and 70 and 80 of the Code of Civil Procedure. Yes, friends. Now I will take you to the special proceedings. Alva, you more proceedings entire C.P.C irodu ಇದನ್ನ ಯಾವ ರೀತಿ ಬೇಕಾದ್ರೆ ನಾವು ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಲಿಂಕ್ ಮಾಡ್ಕೊಂಡು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಹೋದ್ರೆ ಲೆಂತಿ ಇದೆ. ಓಕೆ, ರೆಲೆವೆಂಟ್ ಪಾಯಿಂಟ್ಸ್ ನಾನು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಎಸ್, ವಾಟ್ ಈಸ್ ಸ್ಪೆಷಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್? ನೀವು ಎಲ್ಲ ಗೊತ್ತಿದೆ ಈಗ. ದಿ ಲಾ ಇಸ್ ಅಡ್ವಾನ್ಸ್ಡ್ and all these amendments are made for the purpose of expeditious relief. That is, section 89 is amended to the C.P.C. In section 89 ಏನು ಹೇಳುತ್ತೆ? ಇದು ಪ್ರಾಕ್ಟಿಕಲ್ ಆಗಿ ನಮಗೆ ಅನುಭವ ಇರತಕ್ಕಂಥದ್ದು, ಬುಕ್ ನೋಡೇ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. ಸಿ section 89, after the summons are served, the court will fix a day for appearance of the parties before a civil court. On the date of first appearance of the parties before a civil court, the court either suo motu, it has got power suo motu to refer the matter for mediation. You know the mediation center for the redressal of their grievances amicably. Or upon an application or by a memo with the consent of both parties to a proceedings, the court shall refer the matter to the mediation for the redressal. Then the benefit of, what is the benefit of the mediation proceedings is very important. In a mediation, the mediator will not adjudicate the issue before him. It can only mediate between the parties. He is only a facilitator for the purpose of resolving the dispute among them. They can only guide them, facilitate them. Win-win situation. They can only say, yes, you are the master of your case, and the masters can decide their own grievances for their conveniences in order to avoid the time and other things. Okay. Then they can arrive at an agreement. They can arrive at a mutual agreement on certain terms, voluntary. without any force or coercion or compulsion by any person. If the party come to a common consensus to get their grievances redressed, they will come to an agreement, and the agreement will be drawn and be signed by the parties, and then it will be submitted to the court, which has referred the matter to the mediation. And if the parties agreed to the terms, they will affirm before the court. And if the court sealed that agreement, then it becomes the decree. The two advantages or more advantages of mediation proceedings is to avoid the time, judicial time, avoid the time of the parties, avoid judicial time, and avoid multiplicities of proceedings is one aspect. And when the most important legal remedy available to them is the agreement entered between the parties mutually is not appealable and it is final. Though it is a decree, it is final. That is the importance of special proceedings. And yet another important, the parties might have paid heavy court fee in case of recovery of money, or in case of a suit for declaration in cities like Bangalore and other cities, and the entire court fee has to be refunded to the parties. These are very important, a beneficial proviso that was provided under the special enactment. Then arbitration. Arbitration is now in vogue. So, in an agreement between the parties, an arbitration clause is there. Mandatorily, has got power to refer that matter to the arbitration for the purpose of the resolution of a dispute between the parties. The parties can file an application also, quoting that terms of the contract provides for an arbitration, then it has to be referred to the arbitration. Yes, this is the special proceedings, some of the special proceedings provided under the Civil Procedure Code. Then, friends, I will take you to very, very important area, that is section 94 of the Code of Civil Procedure, that is called supplementary proceedings. If three aspects proceedings, civil proceedings, you can go in entirety. One definition clauses now meet madado, and the second part is incidental proceedings. Then special proceedings we have discussed, and now the supplementary proceedings we are going to discuss now. Section 94 read with section 39 rule 1 at C.P.C. This is a very, very vast area. We need to discuss about this. Well, friends, what is section 94 speaks? Section 94 is a section provided to the parties to enforce or exercise in case of the relief of preventive relief and also enforcing relief. The court has got power invoking section 94, read with section 38 rule 5 and 39 rule 1 and 2 is very important. We cannot read section 94 independently. We have to read these two sections in consonance or in conjunction with section 39, 38 rule 5 and 39 rule 1 and 2. First to section 38 ಹೇಳ್ಬಿಡೋಣ. What section 38 rules speaks about? See, there is a contract between the parties insofar as the recovery of money. There is an agreement, there is a pronote, there are instruments, negotiable instruments, and the rights and liability created under the relevant instruments. But the party, in violation of the terms of the contract and contrary to the instrument where the liability is fixed, want to sell the property, wants to remove the property from the place where it exists. In such a circumstances, what is the remedy available to the party? He must file a suit first, and then he can file an application under Order 38 Rule 5, seeking an ex parte order of an attachment before judgment. This is very, very important discretionary power conferred under the court to grant such. What is an attachment before judgment, and under what circumstances the court will grant ex parte? This is an important area. So this is the prohibitory orders and preventive orders against the defendant to be granted only upon satisfaction of the case made out by a party to grant. Yes. In case if a party wants to remove the property from the place by way of selling, disposing, alienating, demolishing, dismantling, whereby dismantling the existing right of the plaintiff over the property. The issue to be noted here, a party will have the rights created under various modes. One of the modes is by contract. Contract creates the rights and liabilities between the parties. When such a right is committed a breach by the other, then he can enforce. So contract create right to enforce. If one party has a right to enforce, right, other party fails to enforce, then the list creates between the two parties. And when that list is pending before the competent court to adjudicate, during that period, the subject matter of the suit shall exist and shall available for the final decision. If it is removed, if it is destroyed, if it is dismantled, the very purpose of the suit will be defeated. Ultimately, the rights of the parties also be defeated. In order to protect the rights of the parties, the courts can exercise the discretionary power. In all the interlocutory applications, the court will have the discretionary power to consider, illi dispose anadkina bala mukyavada pada, to consider the applications filed by the parties in the proceedings. Right? So the court may pass an ex parte order directing the defendants to not to alienate the property. One. the plaintiff must establish here prima facie case establish ಮಾಡಬೇಕು. ಅಂದ್ರೆ he has a right to have the protection against the defendant not to dispose of the property during the pendency. And he must state the true facts before the court to gain. ಇದು temporary injunction ಏನಂತಂದ್ರೆ it is an equitable order, a discretionary order. The parties must gain the order and not grab or demand the order. ಇಲ್ಲಿ ಡಿಮಾಂಡ್ಗೆ ಅವಕಾಶ ಇಲ್ಲ, ಗೇನ್ ಮಾಡಬೇಕು. ಗೇನ್ ಥ್ರೂ ಎ ಪ್ರಾಪರ್ ಪ್ಲೀಡಿಂಗ್ಸ್. ಪ್ಲೀಡಿಂಗ್ಸ್ ಅನ್ನೋದು ನೆಕ್ಸ್ಟ್ ಬರ್ತದೆ, ರೈಟ್? So you must satisfy the court that he is making efforts to dispose of the property by producing certain prima facie materials before the court. That is one aspect of the matter. 38 Rule 5. The supplementary proceedings. So pending idaga. That is why it is called the supplementary. During the pendency of the petition, any number of applications may be filed by the either parties to the suit to claiming interim orders by the courts of law. This is one such interim order, order 38 Rule 5. Then yavaga certain how the court could dispose of this applications. It is not necessary that always the court will grant a temporary injunction ex parte. In case of order 38 Rule 5 ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ತದೆ, invariably the court will immediately issue an emergent notice to the defendant asking him to appear before the court and demanding him, directing him to furnish a security for the value of the above. ಇಲ್ಲಿ ಉದ್ದೇಶ ಏನು? To ensure that the property subject matter shall subsist till the disposal of the suit between the parties. In that situation and circumstances, the court may order emergent notice to the defendants to appear before the court and to offer security either by way of bank guarantee or by way of offering any other immovable property to the value of the suit property. Yes. Next, when the security is not granted, when the security is not provided, ತೋರ್ಲಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಕೋರ್ಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ಸೆಕ್ಯೂರಿಟಿ ಕೊಡಪ್ಪ ನೀನ್ ಮಾರಾಟ ಮಾಡ್ದಂಗೆ ಅದು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ಸೆಕ್ಯೂರಿಟಿ ಕೊಡ್ಲಿಲ್ಲ, then the court has no option but to pass an order not to alienate or to dismantle the property, which is the subject matter of them. In case the court has also power to arrest and to keep the party in civil prison in case of violation of the disobedience or violation of the orders of the case paper. Then I will take you to section 39 Rule 1 and 2. This is also a supplementary proceedings alva. Section 38 5 ondaitu. Then ಈ section 39 1 and 2 ನ ನಾವು ಎಷ್ಟು ದಿವಸಗಳು ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರು ಕೂಡ ಮುಗಿದ ಕತೆ. ಬಿಕಾಸ್ ಅದು ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್. ಡಿಸ್ಕ್ರಿಷನರಿ ಪವರ್ನ ಹೇಗೆ ನಾವು ಕ್ಲೇಮ್ ಮಾಡಬೇಕು ಅಂತ ಪ್ಲೈಂಟ್ ಅಲ್ಲೂ ಹೇಳ್ಬೇಕು, ಅಫಿಡವಿಟ್ ಅಲ್ಲೂ ಹೇಳ್ಬೇಕು. ವೆನ್ ದಿ ಕೋರ್ಟ್ ವಿಲ್ ಪಾಸ್ an order under section under order 39 Rule 1 and C.P.C is a very, very big area. Anyway, we'll have to touch few ingredients, essence of 39 Rule 1 and 2. Well, friends, as already said in previous 38 Rule 5 ಅಲ್ಲಿ ನಾನು ಡಿಸ್ಕಸ್ ಮಾಡುವಾಗ ಹೇಳಿದೆ discretionary power ಅಂತ. Friends, now this is an equitable remedy. The court will pass an order here. Kindly bear in mind the distinction between an order and that of a decree. What is an order? Order means passed by the court on the interim applications other than the decree. Right? ಸೊ 39 ರೋಲನ್ 2 ಯಾವಾಗ ಕೊಡ್ತಾರೆ? ಏನನ್ನ ಪ್ಲೀಡ್ ಮಾಡಬೇಕು, ಏನನ್ನ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಬೇಕು. ಇಲ್ಲಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡೋದಕ್ಕಿಂತ we have to satisfy the court about the existence of a right in a party who approaches the court, especially seeking interim order of 39(1). When, see, the party has to establish prima facie the existence of a right. First thing. Then the party must establish that there is a likelihood of invasion of his civil rights by the other party. ಬಹಳ ಮುಖ್ಯವಾದ್ದು. Of course, the invasion and the word only actually I have read some of the decisions and borrowed that here. The invasion of a right of a party. Invasion ಅಂದ್ರೆ ಏನ್ ಹೇಳ್ತೀರಿ ಕನ್ನಡದಲ್ಲಿ? ದಾಳಿ. ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಪ್ರಸ್ತುತ ಹಕ್ಕುಗಳನ್ನ, ಸ್ಥಾಪಿತವಾದ ಹಕ್ಕುಗಳು, established rights of a party has been invaded. Apprehension of invasion of an established civil right of a person, then the court can interfere in protecting such right. See, ದಾಳಿ, established civil right ಮೇಲೆ ದಾಳಿ ಮಾಡ್ತಕ್ಕಂಥ ಸಂದರ್ಭವನ್ನ ಪ್ರಸ್ತಾಪ ಮಾಡಿ ಮೇಲ್ನೋಟಕ್ಕೆ ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡಿದ್ರೆ ಕೋರ್ಟ್ನ ಅಂತಹ ಒಂದು ಸ್ಥಾಪಿತವಾದ ಹಕ್ಕನ್ನ ಉಳಿಸ್ಲಿಕ್ಕೋಸ್ಕರ ಕೋರ್ಟ್ ವಿಲ್ ಗ್ರಾಂಟ್ ಫಸ್ಟ್ ಕೇಸಸ್ ವೆನ್ ದೆರ್ ಈಸ್ an apprehension of removal of the property, removal by way of destruction, right? Demolition, right? Dispossession. These are the very, very important area. One apprehension of invasion of an existing civil rights. Secondly, infringement of civil rights. Thirdly, apprehension of dispossession. Apprehension of demolition. Apprehension of dismantling. Apprehension of alienation. Apprehension of illegal taking possession. Apprehension of trespass. Apprehension of causing loss. And such other various facts and circumstances. The court may come to the rescue of the person to protect the established and existing right of one person against an unlawful act of the other persons. This is very, very important area. So, ನೀವು ಟೆಂಪರರಿ ಇಂಜಂಕ್ಷನ್ ನಲ್ಲಿ ನೀವು ಅಫಿಡವಿಟ್ ನಲ್ಲಿ ಹೇಳ್ಬೇಕಾದಾಗ ದಿ ನೇಚರ್ ಆಫ್ ಅಪ್ರಹೆನ್ಷನ್ ಆರ್ ದ ಡೇಂಜರ್ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬೇಕು. ಯು ಮಸ್ಟ್ ಸ್ಪೆಸಿಫಿಕಲಿ ಸ್ಟೇಟ್. ಒಂದೊಂದು ಕೇಸಲ್ಲೂ ಒಂದೊಂದರ ಡಿಫರೆನ್ಸ್ ಇರ್ತದಲ್ವಾ? ಅದು ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಯು ಮಸ್ಟ್ ಶೋ ಪ್ರೈಮಾ ಫೇಸಿ ದಟ್ ಯು ಹ್ಯಾವ್ ಗಾಟ್ ಎ ರೈಟ್ ಇನ್ ದಟ್. And secondly, that existing right is a danger by the dangerous act of the other party. That dangerous act leading to causing injury to the person, injury to his reputation, Injury is property. Injury is possession. And such other things. Therefore, you must plead and establish prima facie that you have got a right in a list. This is very important. ಒಂದು ಲಿಸ್ಟ್ ಅಂತ ಏನ್ ಹೇಳ್ತೀವಿ, ಆ ಕೇಸ್ ನಲ್ಲಿ ಇರತಕ್ಕಂತ ಫ್ಯಾಕ್ಟ್ ಇನ್ ಇಶ್ಯೂ, ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಅಂತ. ಜಗಳ ಅಲ್ವೇ, ದಾವೆಯಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ವಸ್ತುಸ್ಥಿತಿ ಅಂತ ಕರಿತೀವಿ ಲಿಸ್ಟ್ ಅನ್ನೋದ ಕನ್ನಡದಲ್ಲಿ. ಆ ಲಿಸ್ಟ್ ನಲ್ಲಿ ನಿಮಗೆ ಅಧಿಕಾರ ಇದೆ, ಹಕ್ಕಿದೆ, ಆ ಹಕ್ಕಿನ ಒಂದು ದಮನ ಆಗ್ತಾ ಇದೆ. ಹಾಗಾಗಿ ಆ ಹಕ್ಕನ್ನ ಸ್ಥಾಪನೆ ಮಾಡಿ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚಿತವಾಗಿಯೇ ಆ ಹಕ್ಕು ಹಾರು ಹೋಗಬಾರದು. ರೈಟ್? ಹಾಗಾಗಿ ನೀವು ಪ್ರೊಟೆಕ್ಟಿವ್ ಆರ್ಡರ್ ಅಂಡ್ ಇಂಜೆಕ್ಟಿವ್ ಆರ್ಡರ್ ಕೊಡಿ, ರೆಸ್ಟ್ರೈನಿಂಗ್ ಹಿಮ್ ಫ್ರಮ್ ಇಂಟರ್ಫಿಯರಿಂಗ್. ನಾನು ಸ್ವಾಧೀನದಲ್ಲಿ ತೊಂದರೆ, ಇಷ್ಟೇ ನಮಗೆ ಗೊತ್ತಿರೋದೇನು, ಓನ್ಲಿ ಒನ್ ರೈಟ್. ಎಸ್, ರೆಸ್ಟ್ರೈನಿಂಗ್ ಹಿಮ್ ಫ್ರಮ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ವಿತ್ ಮೈ ಪೀಸ್ಫುಲ್ ಪೊಸಿಷನ್ ಅಂಡ್ ಎಂಜಾಯ್ಮೆಂಟ್ ಅಷ್ಟೇ ಹೇಳ್ತೀವಿ ನಾವು. ಅಷ್ಟೇ ಅಲ್ಲ, ಇಂಜಂಕ್ಷನ್ಗೆ ಇಕ್ವಿಟಬಲ್ ಅವ್ರಿಗೆ ಎಷ್ಟೆಷ್ಟಿದೆ ನೋಡಿ. ರೈಟ್? ಅವ್ರ ಕೋರ್ಟ್ ಹೇಳಿದ ತಕ್ಷಣ ವಾಟ್ ಇಸ್ ದಿ ಕೇಸ್ ಅಬೌಟ್, ವಾಟ್ ಇಸ್ ದಿ ಇಂಜಂಕ್ಷನ್ ಫಾರ್, ನೋಟ್ ದೇರ್ ಇಸ್ ಎ ಥ್ರೆಟ್ ಆಫ್ ಡಿಸ್ಪೊಸೆಷನ್, ನಾನು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದೀನಿ, ಅವರು ಡಿಸ್ಪೊಸೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಇಲ್ಲಿಗಲಿಗೆ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಎ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಅಂಡ್ ಟೆನೆಂಟ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಎಸ್, ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಐ ಮೀನ್ ಪೊಸಿಷನ್ ಅಂತ ಒಂದು ರೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್, ರೆಂಟ್ ರೆಸೀಟ್ಸ್ ಇಸ್ ಎನಫ್, ಅಂಡ್ ದಿ ಅದರ್ ಕಾರ್ಡ್ ಟು ಶೋ ದಟ್ ಯು ಆರ್ ಇನ್ ಪ್ರೈಮ್ ಆಫೀಸ್ ತೋರಿಸಿದ್ರಲ್ಲ, ಎಕ್ಸ್ಪರ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಕೊಡ್ಲೇಬೇಕು. ಯು ಮಸ್ಟ್ satisfy the court by producing the relevant documents for the purpose of granting an injunction. ಒಂದಾಯ್ತಲ್ಲ, ನಾಟ್ ಟು ಡಿಸ್ಪೋಸ್ ವಿತ್ ಡ್ಯೂ ಪ್ರೋಸೆಸ್ ಆಫ್ ಲಾ ಇನ್ ದ ಟೆನೆಂಟ್ ಅಂಡ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ರಿಲೇಶನ್ಶಿಪ್ ಎಲ್ಲ ಸಿಗುತ್ತೆ. ಸೊ ಇನ್ ಕೇಸ್ ಆಫ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಆಫ್ agreement, that agreement is registered agreement, you have paid the major consideration, and in the agreement there was a recital that the property, possession of the property has been given, and what is the source open for the party? Party has to seek an ex parte, not to alienate the property. See, alienate property maradrinda a legal injury is being caused. This is very, very important. His statutory right has been created under an agreement of sale which is registered before the competent authority. If in contravention of, in violation of such a recital or a cause, if that property is sold, what is the effect? It not only affects to the individual right of the parties, it affects the statutory violation. So therefore, that action has to be restrained. Right? As a state, state anta nanu heliದಾಗ section 80 C.P.C ನಲ್ಲಿ, all a time in possession. See, without notice to me, he will try to come and demolish. ಇವಾಗ BBMP ತಗೊಳ್ಳಿ, ಡೆಮಾಲಿಷನ್ ಮಾಡಕ್ ಬರ್ತಾರೆ, BDM ನವರು ಡೆಮಾಲಿಷನ್ ಮಾಡಕ್ ಬರ್ತಾರೆ in Bangalore ನಲ್ಲಿ. ಆಗ we have to establish that yes, we are in possession, that not to demolish the building in existence. Right? Yes, these are the ingredients of section 39 rule 102. Yes, now ಇಲ್ಲಿ ಬಹಳ ಮುಖ್ಯವಾಗಿ ನೀವು ಇಕ್ವಿಟಬಲ್ ರಿಲೀಫ್ ಕೇಳಬೇಕಾದಾಗ ಸೆಕ್ಷನ್ 39 1 and 2 ನಲ್ಲಿ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀವಿ. ಸೆಕ್ಷನ್ 39(3) ಇದೆ. ಇದು ಪ್ಯೂರ್ಲಿ ದಿ ಕೋರ್ಟ್ ಡಿಸ್ಕ್ರಿಷನ್ ಅಂಡ್ ಕೋರ್ಟ್ ಡಿಮೈನ್. Ex parte injunction is not an automatic. You must state, invariably ನಾವೇನಾಗ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ, ಆರ್ಡರ್ 39 rule 1 and 2 is enough. 39 rule 3 ನಲ್ಲಿ ಯಾರೂ ಅಪ್ಲಿಕೇಶನ್ ಆಗಲ್ಲ ನಾರ್ಮಲಿ, ವಿಚ್ ಐ ಹ್ಯಾವ್ ಸೀನ್ ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಪ್ರಾಕ್ಟೀಸ್. ಇನ್ ಕೆಲವು ಲೋಕಲ್ ಏರಿಯಾದಲ್ಲಿ ನಾನು ಒಂದ್ಸರಿ ಬೇರೆ ಕಡೆ ಕೋರ್ಟ್ ಹೋಗಿದ್ದಾಗ, ದಿ ಕೋರ್ಟ್ ವಾಂಟೆಡ್ 39 rule 3 ಅಲ್ಲಿ ಅಂತ. ದಟ್ಸ್ ಕರೆಕ್ಟ್ ಅಪ್ರೋಚ್ ಆಫ್ ದ ಕೋರ್ಟ್. ಸಿ, ನೋ ಡೌಟ್ ಯು ಹ್ಯಾವ್ ಅನ್ ಅರ್ಜೆನ್ಸಿ. You must show to the court in a procedural way. Section 39(3) provides that when an application filed under section 39(1) and 2 C.P.C, the party can seek dispensation of notice before passing an ex parte order of temporary injunction. This invariable agi na follow ಮಾಡ್ತಾ ಇಲ್ಲ, ಇದನ್ನ ಮಾಡಬೇಕು. Either by filing an application under section 39 rule 3 before the court seeking dispensation of the notice to the defendant before passing a ex parte temporary injunction, and he must state on oath that why the dispensation is required, and if not, what the prejudice will be caused to the party has to be established in affidavit. Then the court has to satisfy the contents of the evidence pleaded therein, and then it has to pass a separate order saying that an application under 39 Rule 1 and 2 filed, because you are the judicial officers, this is very important. Order 39 Rule 1 and 2 application is filed seeking an ex parte temporary injunction. Consequently, Order 39 Rule 3 application is also filed seeking dispensation of the notice to the defendants. Then I have gone through the contents of the Order 39 Rule 1 and 3, where I'm satisfied that there is an urgency in the matter to grant temporary injunction ex parte. Application under 39 through 3 is allowed and the notice to the defendants is dispensed with. And then I consider the contents of Order 39 Rule 1 and 2, and the core of the party has made a prima facie case to grant an ex parte injunction. Then issue emergent notice and an issue ex parte order of temporary injunction restraining the defendant not to alienate the property or not to interfere with the property and not to demolish the existing building till the next date of hearing. This is very, very important. See, application at a stretch cannot be granted till the disposal of the suit of the Madagbarala. Till the next date of the hearing and temporary injunction. This is the rule of prudence. This is the procedure, and this is the mode of passing a temporary injunction under 39 1 and 2. And upon service of summons, or immediately after the service of summons, if before the date of hearing fixed for hearing by the court, the party may come before the court. And one of the important subsequent proceedings to be followed by a party is immediately after the order that has to be complied with. The order of temporary injunction has to be complied with. How? By sending the copy of the plain affidavit and all other documents filed along with the plain has to be supplied in compliance of Order 39 Rule 3. The non-compliance of the mandatory requirement of Order 39 3, the grant of injunction ex parte will automatically be vacated by the court, disconnected by the court in the next date of hearing if it is brought to the notice by the other side. So this is the major requirements to be followed by a party, and he must convince to get an equitable order of temporary injunction before the court of law. This is insofar as, of course, in various kinds of temporary injunction is there. These are the prima facie case. ಎಷ್ಟು relevant ಅಷ್ಟು ಹೇಳ್ತೀನಿ. See, all that we need to place is relevancy, sufficiency, and relevancy. All right, reliability. Equitable relief ಕೇಳಬೇಕಾದ್ರೆ sufficient to that purpose, relevant to that purpose, and reliable to that purpose. Now document produce ಮಾಡಿದಾಗ reliable ಆಗಿರುತ್ತೆ. Rent agreement cannot be disputed, and registered agreement of sale cannot be disputed. That is reliability of the documents. This is how we must prepare, plead, face, and place before the court to gain the order of interim orders of whatever kind, following the procedure of C.P.C. This is insofar as the supplementary proceedings, which are very, very important. Here, ಒಂದು ಸೆಕ್ಷನ್ 39 ರೂಲ್ 1 and 2 ನೀವು ಸ್ಪಷ್ಟವಾಗಿ ತಿಳ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ನ ಹೇಗೆ ನಾವು ಕ್ಲಿಯರ್ ಮಾಡಬೇಕು ಅಂತ, ಇನ್ನು ಯಾವುದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ, ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ರಿಸೀವರ್, application for appointment of a commissioner for expert evidence, applications for calling for the documents, any applications, ನೀವು ತರೋವಾಗಿ ಪ್ಲೀಡ್ ಮಾಡಿ ಕೋರ್ಟ್ ಇಂದ ನೀವು ಆರ್ಡರ್ ನ ಪಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಯೋಗ್ಯರಾಗಿರ್ತೀರಿ, ಅರ್ಹರಾಗಿರ್ತೀರಿ ಅಂತಕ್ಕಂಥದ್ದು. ಕೇಪಬಲ್ ಆಫ್, I can use that word. You should be capable of getting or gaining the interim orders by the court only when you show all that we need to do is to satisfy the other party, not by satisfying ourselves. What is important is we must satisfy ourselves about the case and also satisfy placing it and satisfy the other. Ultimately, the satisfaction and contentment is of two important issues that requires in every area of our learning. Yes, every area of our learning. Well, friends, I'm satisfied by having discussed about section 94 and section order 39 rule 1 and 2 of C.P.C, and other things. Definitely we can have the same ingredients. Well, friends, now I will come to orders now. Order 1 and most important order is pleadings. Order 6. Yes, what are pleadings? ಇಲ್ಲಿ ಹೇಳಿ, ಇಲ್ಲಿಂದನೇ ಡಿಕ್ರಿಗೆ ನಾವು ಎಂಟ್ರಿ ಹೊಡಿದು ಟು make the court to adjudication of the rights commences from the pleadings and proof of the pleadings. Alva, illi bantu substantive issue to be pleaded in a forum recognized in the C.P.C. Yes, what are pleadings? Pleading is a plural word. Pleadings means and includes the plaint and written statement. Yes, ಸ್ವಲ್ಪ ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗೋಣ ಈಗ. Plaint order 6 in a pleadings ಅಲ್ಲಿ ಏನೆಲ್ಲ ಪ್ಲೀಡ್ ಮಾಡಬೇಕು? Pleadings means plead the facts. ಅಷ್ಟೇ. Pleading ನಾವು pleadings means the plaint and written statement ಅಂತ ಹೇಳಿದಾಗ plaint ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ, written statement ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ. What is to be pleaded in a plaint or written statement? A party shall plead the facts. Fact ಅಂದ್ರೆ ಏನು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಹಿಂದೆ ಹೇಳಿದೆ section 3 of the Evidence Act ಅಲ್ಲಿ. Fact means anything, state of things, relation to things, capable of pursuing by senses and the mental condition of a person anta helde. This is the fact, right? That fact has to be pleaded in the plaint or in the written statement. Fact and fact alone, and the substantive fact and the relevant fact. ಇಷ್ಟು ತಿಳ್ಕೊಂಡ್ರೆ ಸಾಕು. ಅಂದ್ರೆ ಏನೇನೋ ಹೇಳ್ಬೇಡಿ, ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಏನ್ ಬೇಕು ಅದನ್ನ ಹೇಳಿ, ನಿಮಗೆ ಕೇಸ್ ಸಂಬಂಧಪಟ್ಟದನ್ನ ಮಾತ್ರ ಹೇಳಿ, ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಹೇಳಿ, ಬ್ರೀಫ್ ಆಗಿ ಹೇಳಿ. ಲಾನ ಪ್ಲೀಡ್ ಮಾಡಬೇಡಿ, ಎವಿಡೆನ್ಸ್ ಅನ್ನ ಪ್ಲೀಡ್ ಮಾಡಬೇಡಿ, ರಿಸೈಟಲ್ಸ್ ಆಫ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಪ್ಲೀಡ್ ಮಾಡಬೇಡಿ. ಎಂದು ಸಂಕ್ಷಿಪ್ತವಾಗಿರ್ಲಿ, ನೇರವಾಗಿರ್ಲಿ, ನಿಖರವಾಗಿರ್ಲಿ, ಸ್ಪಷ್ಟವಾಗಿರ್ಲಿ ನಿಮ್ಮ ಸಂಗತಿಗಳು. ಸಿ, ಲುಕ್ ಅಟ್ ದ ಬ್ಯೂಟಿ ಆಫ್ ಡಿಸ್ಕಷನ್. ಫ್ಯಾಕ್ಟ್ ಅಂದ್ರೆ ಇಲ್ಲಿ ಸಂಗತಿಗಳು, ಅಲ್ಲಿ ನಾವು ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ನಲ್ಲಿ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಅಂತ, ಘಟನಾವಳಿಗಳು ಅಂತ ನಾವಲ್ಲಿ ಕರಿತಾ ಇದ್ದೋ, ಇಲ್ಲಿ ಸಂಗತಿಗಳು ಅಂತ ನಾವು ಕರಿತೀವಿ. ಯಾವಾಗ ಒಂದು ಎಫೆಕ್ಟಿವ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ನಾವು ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಸ್ನೇಹಿತರೆ? ಸಿ, ಒಬ್ಬ ವ್ಯಕ್ತಿ ಸಂಗತಿಗಳ ಸಂಗಾತಿ ಆದಾಗ ಮಾತ್ರ ನಾವೊಂದು ಎಫೆಕ್ಟಿವ್, ಅರ್ಥಪೂರ್ಣವಾದ ಮತ್ತೆ ಪರಿಪೂರ್ಣವಾದಂತಹ ಪ್ಲೀಡಿಂಗ್ಸ್ ನ ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ. ಇದು ರೆಲೆವೆಂಟ್. ನಾನು ಯಾಕೆ ಕೇಳ್ತಿದ್ದೆ ಇಲ್ಲಿ ಬಹಳ ಒಂದು ಉತ್ಸುಕನಾಗಿ, ವಿತ್ ಎಂಥೂಸಿಯಾಸಮ್, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಎ ಸ್ಟೇಜ್ ಆಫ್ ರೆಲೆವೆನ್ಸ್. ಇಟ್ ಇಸ್ ಎ ಸ್ಟೇಟ್ ಆಫ್ ರೆಲೆವೆನ್ಸ್. ಸೊ ಸಂಗತಿಗಳು ಏನು ಸಂಗತಿಗಳಿವೆ, ಆ ಸಂಗತಿಗಳು ರೆಲೆವೆಂಟ್ ಆಗಿರ್ಬೇಕು, ಮತ್ತೆ ಸತ್ಯವಾಗೂ ಕೂಡ ಇರ್ಬೇಕು, ವಾಸ್ತವವಾಗಿ ಹೋಗಿರ್ಬೇಕು. See, ultimately we are trying to take the decree by proving the fact. ಇಲ್ಲಿ ನಮ್ಮ ಫ್ಯಾಕ್ಟ್ ಮಸ್ಟ್ ಬಿ ರೆಲೆವೆಂಟ್ ಅಂಡ್ ಇನ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್. ವಾಸ್ತವ ಸಂಗತಿಗಳನ್ನ ಹೇಳ್ಬೇಕು, ಸತ್ಯ ಸಂಗತಿಗಳನ್ನ ಹೇಳ್ಬೇಕು, ರೈಟ್? ಅದನ್ನ ಬಹಳ ಪರಿಣಾಮಕಾರಿಯಾಗಿ ಹೇಳ್ಬೇಕು, ಸೂಕ್ಷ್ಮವಾಗಿ ಹೇಳಬೇಕು, ಮತ್ತೆ ಬ್ರೀಫ್ ಆಗಿ ಹೇಳಬೇಕು, ಅದಕ್ಕಿಂತಲೂ ಮುಖ್ಯವಾಗಿ ಸರಳವಾಗಿ ಹೇಳಬೇಕು. ರೈಟ್? ಪ್ಲೀಡಿಂಗ್ಸ್ ಮಸ್ಟ್ ಬಿ ಸಿಂಪಲ್. ಕ್ಲಾರಿಟಿ ಇರಬೇಕು, ಅರ್ಥವಾಗಬೇಕು. ಯಾರಿಗೆ? ನಮಗೆ. ದ ಪರ್ಸನ್ ಹೂ ಪ್ಲೀಡ್ಸ್ ಮಸ್ಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಈಸ್ ಪ್ಲೀಡಿಂಗ್. ಲುಕ್ ಅಟ್ ದ ಬ್ಯೂಟಿ ಆಫ್ ದಿ ಪ್ಲೀಡಿಂಗ್ ಅಂತಂದ್ರೆ ಏನ್ ನೋಡಿ. ವಾಟ್ ಇಸ್ ಮೀನ್ ಬೈ ಪ್ಲೀಡಿಂಗ್? ಪ್ರಾರ್ಥನೆ ಮಾಡ್ಕೊಳ್ತಕ್ಕಂಥದ್ದು, ನಿವೇದನೆ ಮಾಡ್ಕೊಳ್ತಕ್ಕಂಥದ್ದು. ದಟ್ ಈಸ್ ವಾಟ್ ದಿ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ನಿವೇದನೆ. ದಿಸ್ ಈಸ್ ಮೈ ಕೇಸ್, ದಿಸ್ ಈಸ್ ಮೈ ಕೇಸ್ ಲಾರ್ಡ್, ಇಟ್ಸ್ ಮೈ ಕೇಸ್ ಫಾರ್. ಸಿ, ಇದಕ್ ಬೇಕಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಸ್ವಚ್ಛತೆ. ಯಾವಾಗ ಇಫ್ ಯು ಹ್ಯಾವ್ ಎ ಗುಡ್ ಕೇಸ್, ಏನ್ ಖುಷಿಯಾಗಿ ನಾವು ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ ಗೊತ್ತಾ? ಎಸ್, ಪ್ರಿಪೇರ್ ಎ ಗುಡ್ ಕೇಸ್, ನಾಟ್ ಕ್ರಿಯೇಟ್ ಎ ಗುಡ್ ಕೇಸ್. ಯು ಕ್ಯಾನ್ ಪ್ರಿಪೇರ್. ನಾವು ಸಿದ್ಧಪಡಿಸ್ಬೇಕಾಗ್ತದೆ. ಅದನ್ನ ರೆಲೆವೆನ್ಸಿ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಬಗ್ಗೆ ನಾನು ಇಷ್ಟೊಂದು ನಿಖರವಾಗಿ ಹೇಳ್ಬೇಕಾಗ್ತದೆ. ಓನ್ಲಿ ಫ್ಯಾಕ್ಟ್. ಅದಕ್ಕೆ ತಲೆನೇ ಕೆಡ್ಸ್ಕೊಳ್ಳೋದು ಬೇಕಾಗಲ್ಲ. ನೀವು ತಲೆ ಉಪಯೋಗಿಸ್ಬೇಕು ಅಲ್ವಾ? ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು. ಯು ಮಸ್ಟ್ ಮಾರ್ಷಲ್ ಓವರ್ ದಿ ಫ್ಯಾಕ್ಟ್, ಕಲೆಕ್ಟಿಂಗ್ ಫ್ರಮ್ ಅವರ್ ಪಾರ್ಟೀಸ್. ಏನು ಅವ್ರೇನೇ ಹೇಳಿ, ಪಾರ್ಟಿ ಮೇ ಸೇ ಸಮಥಿಂಗ್, ಎಸ್, ವಿತ್ ಇನ್ ದಿ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಆಫ್ ಲಾ ಬರ್ತದ ಅವರ ಕ್ಲೇಮು ಅನ್ನೋದನ್ನ ನಾವು ನೋಡ್ಬೇಕು. ಕ್ಲೇಮ್ ತಾನೇ ಇಲ್ಲಿ ಪ್ಲೀಡ್ ಮಾಡ್ತಾ ಇರೋದು. ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಬರ್ತಕ್ಕಂಥದ್ದು ಕ್ಲೇಮ್. ಅಲ್ಲಿ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತ ನೆಕ್ಸ್ಟ್ ಬರ್ತದೆ, ನಾನು ಹೇಳ್ತೀನಿ. ರೈಟ್? ಎಸ್, ಕ್ಲೇಮ್. ಆ ಕ್ಲೇಮ್ ಅಲ್ಲಿ ಇವರಿಗೆ ರೈಟ್ ಇರಬೇಕು. ಆ ರೈಟ್ ಬರುತ್ತಾ ಈ ಫ್ಯಾಕ್ಟ್ ಅಂಡ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಅಲ್ಲಿ? ಈ ಸಂಗತಿ ಮತ್ತು ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಸಂದರ್ಭಗಳಲ್ಲಿ ಬರುತ್ತಾ ಅನ್ನೋದನ್ನ ನಾವು ಅಸೆಸ್ ಮಾಡಿ ಅದನ್ನ ಪ್ಲೀಡ್ ಮಾಡ್ತೀವಲ್ಲ, ನಿವೇದನೆ, ಪ್ರೆಸೆಂಟಿಂಗ್. ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಫ್ಯಾಕ್ಟ್, ಸಬ್ಸ್ಟಾಂಟಿವ್ ಫ್ಯಾಕ್ಟ್. ಎಸ್, ಕೆಲವು ಸಾರಿ ನಾವು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಸಿಚುವೇಶನ್, ಆರ್ಡರ್ 6 ರೂಲ್ 4 C.P.C ನಲ್ಲಿ ಒಂದು ಪ್ರಮುಖವಾದಂತ ಒಂದು ಅಂಶ ಇದೆ. ವೆನ್ ಯು ಪ್ಲೀಡ್ ಎ ಫ್ರಾಡ್, ವೆನ್ ಯು ಪ್ಲೀಡ್ ಎ ಮಿಸ್ರೆಪ್ರೆಸೆಂಟೇಷನ್, you must narrate Order 6 Rule 4 ನಲ್ಲಿ specifically and substantially. This is the importance of pleading, my friends. ನೀವು when you plead a fraud, ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವು invariably, he has played a fraud before the court, he has played a fraud before the authority. No, don't use that negative word repeatedly. That is very bad pleading. If you are confirmed that the fraud has been played, ಯಾವ ರೀತಿನಲ್ಲಿ, ಎಲ್ಲಿ, ಯಾರಿಗೆ, ಹೇಗೆ, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ, ಯಾವ ರೀತಿನಲ್ಲಿ, you must narrate the nature of fraud, the manner in which is caused, to whom it was affected, and what right of the other person affected, and how he has gained by affecting the other person. How wrongfully he has made a wrongful gain, causing wrongful loss to the other, has to be invariably, specifically, concisely, properly, truly to be pleaded. That is called the specific pleading. That is called the relevant pleading. It is a demand of the procedure, requirement of a procedure to plead a fraud. Because friends, when you plead a fraud vitiate all Solomon acts. This is the substantive discussion. Now we started to know about the pleadings. See, fraud vitiate all Solomon acts. Therefore, you must emphasize, don't plead fraud very casually. ತಗೊಳಕ್ಕೆ ಹೋಗಬೇಡಿ. I got a right ಅಂದ್ಬಿಡಿ ಸಾಕು. He has played a fraud ಅಂತ ಹೇಳೋದು ತುಂಬಾ ನೆಗೆಟಿವ್ ಪದ. ಅದು ಬಹಳ ಸೂಕ್ಷ್ಮವಾಗಿ ಯೋಚನೆ ಮಾಡಿ. ಅದನ್ನೇ ಬಳಸ್ಬಿಡ್ತೀವಿ ಎಲ್ಲಾ ಕಡೆನು. ನೋ, ಬೇಡ. ಬಿ ಫೇರ್. ಸೊ ನಿಜವಾಗ್ಲೂ ಅದು ಫ್ರಾಡೆ ಆಗಿದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ ನಿಖರವಾದಂತಹ ಮಾಹಿತಿಗಳನ್ನು ನೀವು ಪಡ್ಕೊಂಡು ಸ್ಪಷ್ಟವಾಗಿ ಅದನ್ನ ನಿವೇದನೆ ಮಾಡಿ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ನಲ್ಲಿ, ಅವಾಗ ಮಾತ್ರ ಉತ್ತಮವಾದ ಕ್ಲೈಂಟ್ ಅಂತ ಅನ್ಸ್ಕೊಳ್ತದೆ. ಹೌದಲ್ವಾ? ನೋಡಿ, the importance of pleading a fraud. When the fraud vitiate all Solomon acts, nullity, then there is no limitation to claim the relief under the fraudulent act. ಈಗ ಫ್ರಾಡ್ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ ಅದಕ್ಕೆ. On playing fraud to the government, a money has been swindled, synchronize the public fund. Anta sandarbhadalli limitation is no matter. The court condonation of questionable limitation. When the fraud come to knowledge is enough. So therefore, the importance of pleadings are important too. Other things have rights bantu anta nivella helbiಡ್ತೀರಿ. It's not easy. It's not. It is an easy fact. In due course of we are pleading. But when so far as the fraud to be pleaded, then we must specifically and emphatically plead the fraud because of the couple of purposes to be served here. Yavadu ondu, you will establish at a later stage and succeed, and you will give an opportunity to the other side to defend. Parties may admit certain things. If the fact is genuine and true, other party in the defense you can admit certain things. Suppose if there is a second marriage, second marriage may be admitted by the defendant. Of proof ke avakasha iralla. Otherwise, ellanu deny ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. ಅವಾಗ ಬರ್ಡನ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ plaintiff ಗೆ. ಒಂದು, enabling the party to admit the true facts and to have a proper defense to the disputed fact. That is the scope and important impact of the pleading of fact in a plaint or a written statement, friends. And yet another important aspect is, in case of an immovable property, the existence of the property in its measurement and its boundary and in its mode of acquisition is disputed. You must specifically plead the nature of the property. Nature of the property is whether it is an agricultural property, whether it is a commercial property, whether it is a site, whether it is a building, whether it is a building and vacant site. Angidaga, proper identity of the property is very, very important in case of suit for declaration and for possession. ಬಹಳ ಮುಖ್ಯವಾದ್ದು. ನೀವು ಬೇರೆ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ಗೆ ಪ್ಲೀಡಿಂಗ್ ಮಾಡ್ತಕ್ಕಂಥದ್ದೇ ಒಂದಿರ್ತದೆ. ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸೆಷನ್ ಇದೆಯಲ್ಲ, in case of declaration of possession of a property, vacant property coupled with the construction property iddaga, unless there is a specific pleadings to that effect, what is the extent of the building existing in the property, right? What is the extent of the vacant property, and what is the document that you have produced to prove the title to the property. In a suit for declaration, friends, the title has to be pleaded and proved by producing a primary document. ಇದು ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲಿ ನಾವು ಕಾಣ್ತಕ್ಕಂತ ಒಂದು ರಿಧಮ್ ಅಂತ ಹೇಳ್ತೀವಿ. ಅದು ಯಾನ ಅಥವಾ ಗಾನ, ರಿಧಮ್ ಕಾಣ್ತಕ್ಕಂಥದ್ದು ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲಿ ಎಂಜಾಯ್ ಮಾಡ್ಬೇಕು. ಯಾವಾಗ? ವೆನ್ ವಿ ಆರ್ ಅಥಾರಿಟಿ, ಅಥಾರಿಟಿನ ಅಕ್ವೈರ್ ಮಾಡ್ಕೋಬೇಕು by practice and by reading. So therefore, in a suit for declaration and possession specifically ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ, right? In case of an immovable property, that description of the property with the extent of the boundary has to be specifically pleaded and to be proved by a primary document. ಯಾತಕ್ಕೆ ಹೇಳಿ? Though you have obtained the decree must be capable of executing. You must capable of enforce decree and to relish the fruits of the decree. ಆ ಡಿಕ್ರಿ ಎಲ್ಲ ಫಲವನ್ನ ಅನುಭವಿಸ್ತಕ್ಕಂಥದ್ದು ಅನುಭೋಗ ಅಂತ ಕರೀತಾರೆ. ಎಂಜಾಯ್ಮೆಂಟ್ಗೂ ಕನ್ಸಂಪ್ಷನ್ಗೂ ವ್ಯತ್ಯಾಸ ಇದೆ. See, the decree must be capable of consumption to a person who attained or obtained by a court of law. Therefore, friends, pleading very, very important alva. Irade suit illinda shuruvagodu ಆರಂಭ, ರೈಟ್? ಆರಂಭ ಅಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಅಗ್ರಿಕಲ್ಚರ್ ಕೂಡ ಅಂತೇಳಿ ಕೃಷಿ ಅಂತ ಕರೀತಾರೆ. ಆರಂಭ ಅಂದ್ರೆ ಇನಿಸಿಯೇಷನ್. right? Initiation with the pleadings to contain facts, only facts, nothing but facts, substantive facts, true facts, honest facts, and facts with derived from the documents and that of an oral evidence which you have collected, and to be concisely plead in the form of pleadings, that is called the plaint and the written statement. That is the import and the importance of the pleadings. Well, friends, now I'll come to the plaint now, order 7 or 1, 2, so many rules which extends. Yes, I will give the brief particulars of a plaint. ಈ plaint ಅಲ್ಲಿ ನೋಡಿದ ತಕ್ಷಣ ನಿಮಗೆ ಮೇಂಟೈನ್ ಆಗುತ್ತಾ, ಡಿಕ್ರೀಸ್ ಸಿಗುತ್ತಾ ಅಂತ ನೀವು ಕ್ಲೈಂಟ್ ಅವರ್ ಮೆಂಟನಲ್ಲೇ ನೀವು ಸ್ಯಾಟಿಸ್ಫೈ ಮಾಡೋದು ಕೋರ್ಟ್ಗೆ. ಫಸ್ಟ್ ವಿಲ್ ಸ್ಯಾಟಿಸ್ಫೈ. ನೋಟ ಇದೆಯಲ್ಲ, ಅದು ಬಹಳ ಮುಖ್ಯ. ನೋಟ ಯಾವಾಗ ಬರುತ್ತೆ? ಇವನ ಮನಸ್ಸಲ್ಲಿದ್ದಾಗ. ಆ ಒಂದು ಚಿತ್ರ, ಈ ಪ್ಲೈಂಟ್ ಇದೆಯಲ್ಲ, ಈ ಪ್ಲೈಂಟ್ ವಾದಪತ್ರ, ಆ ವಾದಪತ್ರದ ಚಿತ್ರ ನಿಮ್ಮ ಚಿತ್ತದಲ್ಲಿ ಉದ್ಭವ ಆಗ್ಬೇಕು. ಅವಾಗ ಮಾತ್ರ ನೀವು ಎಫೆಕ್ಟಿವ್ ಪ್ಲೈಂಟ್ ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ ಪರಿಣಾಮಕಾರಿಯಾದಂತಹ ಒಂದು ವಾದಪತ್ರವನ್ನ ಮಂಡಿಸ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಆಗತ್ತೆ. ಈ ವಾದಪತ್ರವನ್ನು ನೀವು ಮಂಡಿಸಬೇಕಾದಾಗ ಕೇವಲ ಸಿವಿಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ಪ್ರಕ್ರಿಯೆ ಅಷ್ಟೇ ಗೊತ್ತಿದ್ರೆ ಸಾಲದು. ಯು ಮಸ್ಟ್ ನೋ ದಿ ಸಬ್ಸ್ಟ್ಯಾಂಟಿವ್ ಲಾ ಆಲ್ಸೋ. You are pleading your substantive rights acquired and existing as on the date of the suit, which was of under the mercy or danger on the other side. To protect your existing right, you must plead. To plead, you must know the substantive right of you having acquired in a different source that has to be narrated simply by describing the said acts, activities concisely, descriptively, simply, briefly before the court. Therefore, the plaintiff at a first stretch, at a first look, to be the plaint. ಒಂದು ವಾದಪತ್ರವನ್ನ ನೋಡಿದ ತಕ್ಷಣ ಅದು ವಾದಪತ್ರ ಅಂತ ನಾವು ಪತ್ತೆ ಹಚ್ಚಬೇಕಾದ್ರೆ ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಕೆಲವು ವಿಸ್ತೃತವಾದ ಅಂಶಗಳನ್ನ ನಾವು ಮೇಲ್ನೋಟಕ್ಕೆ ಗಮನಿಸಬೇಕಾಗ್ತದೆ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್, ಕಾಸ್ಟ್ ಟೈಟಲ್, ಶೀರ್ಷಿಕೆ ಅಂತ ಕರೀಬಹುದು. ಏನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ನಿಮಗೆ ಗೊತ್ತಾಗ್ತದೆ? ಏನಿದೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಗೊತ್ತಾ? ದ ಕೋರ್ಟ್ before which you are placing the plaint. ಇಲ್ಲಿ ಕೋರ್ಟ್ ಇಂದಾಗ ಇಟ್ಸ್ ನಾಟ್ ಬಿಕಾಸ್ ಆಫ್ ಫಾರ್ಮ್ಯಾಲಿಟಿ. ನಾವೇನ್ ಹೇಳ್ತೀವಿ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ, ಎಸ್ ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ರಿ ಅಷ್ಟೇ. ಕೋರ್ಟ್ ಆಫ್ ಸಿವಿಲ್ ಜಡ್ಜ್ ಜೂನಿಯರ್ ಆರ್ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಆರ್ ಕೋರ್ಟ್ ಆಫ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಆರ್ ಹೈ ಕೋರ್ಟ್ ಆರ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅನ್ ಅಪೀಲ್ ಆರ್ ರಿವಿಷನ್. ನೋ, ಪ್ಲೇಂಟ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಬಿಫೋರ್ ವಿಚ್ ಕೋರ್ಟ್, ವೈ ಯು ಹ್ಯಾವ್ ಸೆಲೆಕ್ಟ್ ದಟ್ ಕೋರ್ಟ್ ಓನ್ಲಿ? Because you must find out the territorial jurisdiction of the court. You must find out the pecuniary jurisdiction of the court. Before which court you are filing the suit, you must understand this and then to plead. Because you should decide first that whether this court has jurisdiction to try and give a relief what you have sought in the prior. That is the selection of the court on the ground of territorial jurisdiction and on the ground of pecuniary jurisdiction. Aita, selection is clear. Kevalas, not a mere formality. ಈ ರೀತಿ ಸ್ಪಷ್ಟತೆ ಇರಬೇಕು ಅಂತ ನಾನು ಹೇಳ್ತಕ್ಕಂಥದ್ದು ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. ನೆಕ್ಸ್ಟ್, ಪಾರ್ಟೀಸ್ ಬಹಳ ಮುಖ್ಯ ಫ್ರೆಂಡ್ಸ್. ಇಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಅಲ್ಲಿ ನಾವು ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಅಂತ ಆಗ್ಲೇ ಓದೋ ಸೆಕ್ಷನ್ 211 ಅಲ್ಲಿ ಇಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಯಾರಿರ್ಬೇಕು? ನಾಟ್ ಎನಿ ಪರ್ಸನ್ ಅಂಡ್ ಎವ್ರಿ ಪರ್ಸನ್ ಕೆನಾಟ್ ಸ್ಯೂ. ಆಲ್ ಪರ್ಸನ್ಸ್, Alva? Who are the proper parties against whom you are claiming the relief? Who shall be the plaintiff? Plaintiff or plaintiff must have the existing legal right in a property mentioned in the schedule or in a list. The subject matter of the suit, that is called the list. The person, right, being the plaintiff, must have the list and should have the fruits of the list. For instance, in a matrimonial case, for example, dispute with regard to the husband and wife, Alva, about the harassment meted out to the husband, which attracts 13(1)(a) and B of the Hindu Marriage Act of 1955. Divorce on the ground of cruelty and desertion. Who is the necessary party here? It is the husband, always. Why you will make the mother? Why you will make the sister? Why you will make the brother? So, though it is simple in its nature, you must understand seriously to explain or define who are the parties. So, similarly, who shall be the defendant? It is not the mother-in-law, father-in-law, some third person. It is the wife alone. It is just for an example I said. There plaint andre ಎಷ್ಟು ಸೂಕ್ಷ್ಮವಾಗಿ ನಾವು ಡ್ರಾಫ್ಟ್ ಅನ್ನು ಮಾಡಬೇಕು, ಎಷ್ಟು ಪರಿಣಾಮಕಾರಿಯಾಗಿ, ಎಷ್ಟು ಉತ್ತಮವಾಗಿ, ಎಷ್ಟು ಸ್ಪಷ್ಟವಾಗಿ ನಾವು ಹೇಳಬೇಕು ಅಂತ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ವಾ. ಅಂಡ್ ದೆನ್ ಇನ್ ಎ ಸಿವಿಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಬರೋಣ. ಯು ಸಿ ಇನ್ ಎ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್, ಪಾರ್ಟೀಸ್ ಬಹಳ ಮುಖ್ಯ ಇಲ್ಲ ಆಗ್ತದೆ ಅಲ್ವಾ. ಇನ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ದಿ decision of recent decision in 6A ನಲ್ಲಿ, who are all the necessary parties, whether the married daughters or not, whether the father is alive or not, right? Date of marriage, date of death of a party is not the criteria, but only who are the co-partners, who are entitled to a share in the non-settled property or the self-acquired property of a father upon the death when the succession opens. All are necessary parties who have got right to share in the properties are all necessary and proper parties to determine the shares under Section 6A of the Hindu Succession Act. Or in case of an ancestral property, we have to take out 3 generations of genealogy tree. Always proper ನೀವು ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತಿರಲ್ಲ who are the necessary parties ಅಂತ, ಅವಾಗ್ಲೇ ನಿಮ್ ರಿಲೀಫ್ ಕಂಪ್ಯೂಟ್ ಮಾಡ್ಬಿಡ್ತೀರಾ. ಇನ್ ಕೇಸ್ ಆಫ್ ಅನ್ ancestral property ಎಲ್ಲರಿಗೂ ಬರುತ್ತೆ, ಎಲ್ಲ ಎವರಿ ಬ್ರಾಂಚ್ಗೆ. Then you have studied Section 8 of the Hindu Succession Act. Section 8 ಅಲ್ಲಿ ನೋಡ್ತೀರಿ ನೋಷನಲ್ ಪಾರ್ಟಿಷನ್ ಯಾವಾಗ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ. ಅದು ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವೆಶ್ಚನ್ ನಮ್ಗೆ ಗೊತ್ತಿದ್ದೇನೆ ಪಾರ್ಟಿ ನೆಸೆಸರಿ ಪಾರ್ಟಿ ಮಾಡೋದು. ಇಟ್ಸ್ ನಾಟ್ ಮಿಯರ್ ಮೇಕಿಂಗ್ ಎ ಪಾರ್ಟೀಸ್. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಓಕೆ ಪ್ಲೇಂಟಿಫ್ ಡಿಫಿನೆಂಟ್, ದಟ್ ಬೈ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ನಾಟ್ ಸಫಿಶಿಯಂಟ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಹೂ ಆರ್ ದ ಪಾರ್ಟೀಸ್ ಟು ಎ ಸೂಟ್. ಕಾಸ್ಟ್ ಏಟ್ ಅಂದ್ರೆ ನಾಟ್ ಮಿಯರ್ ತಲೆ ಬರಹ ಅಷ್ಟೇ ಅಲ್ಲ ಸಾರ್, ಆ ತಲೆ ಬರಹಲ್ಲಿರ್ತಕ್ಕಂಥ ತಲೆ ಅಥವಾ ಬ್ರೈನ್. ಇದು ಐ ವಾಂಟೆಡ್ ಟು ಕನ್ವೆ ವಾಟ್ ಈಸ್ ತಲೆ ಬರಹ ಶೀರ್ಷಿಕೆ, ರೈಟ್? ಅಲ್ಲಿ ಬ್ರೈನ್ ಇರಬೇಕು, ಫೋರ್ ಥಾಟ್ ಇರಬೇಕು, ಅಂಡ್ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ನಾವು ಪ್ಲೀಡ್ ಮಾಡ್ಬೇಕು ಅಂತಕ್ಕಂಥ ಉದ್ದೇಶದಿಂದ ನಾನು ಹೇಳಿದೆ ಪಾರ್ಟಿಸನ್. ಇನ್ನು ನೀವು ಎಲಾಬರೇಟ್ ಮಾಡ್ಬೋದು. ಅಂದ್ರೆ ಈ ರೀತಿಯಾದ ಥಿಂಕಿಂಗ್ ಬೇಕಾಗ್ತದೆ ಒಂದು ಕಾಸ್ಟ್ ಟೈಟಲ್ ನ ಪ್ರಿಪೇರ್ ಮಾಡ್ತಕ್ಕಂಥ ಸಂದರ್ಭದಲ್ಲಿ. ಟೆರಿಟೋರಿಯಲ್ jurisdiction, pecuniary jurisdiction, and depends on the nature of the parties. Who are all the parties? ಎಲ್ಲ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬಿಟ್ಟವಲ್ಲ ಸರ್. ಈಗ who are the necessary parties? Order 1 Rule 10 ಮುಂದೆ ಹೋಗಿ ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡೋದಕ್ಕೆ ಬದಲೇ ಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಈಗಲೇ ರೆಡಿ ಮಾಡ್ಬಿಟ್ರೆ, ಯು ಮಸ್ಟ್ ಅಸಿಸ್ಟ್ ದ ಕೋರ್ಟ್ ಫಾರ್ ಎಫೆಕ್ಟಿವ್ ಅಡ್ಜುಡಿಕೇಶನ್ ಆಫ್ ಯುವರ್ ಓನ್ ಕ್ಲೇಮ್. ದಟ್ ಇಸ್ wisdom as well as assisting the court for expedient relief to be claimed by the parties before the court. Yes, sir. Next, we shall go to the pleadings in general and pleadings in particular. Nan aglene order 6 rule 4 helbekaದಾಗ pleadings ಅಲ್ಲಿ ಹೇಳಿದೆ. General pleadings. General ಆಗಿ ನೀವೇನು ಹೇಳಕ್ ಹೋಗಬೇಡಿ. ರಿಲೇಶನ್ಶಿಪ್ ಅನ್ನು ಒಂದು ಹೇಳ್ಬೇಕಾಗ್ತದೆ. Depends on the nature of the relationship. ಹಾಗೆ in case of a suit for ejectment or suit for possession, the defendant is the tenant. Occupied the property by virtue of this agreement under the plaintiff for a sum of rupees 10,000 as a rent monthly to be payable. The lease deed for a period of 11 months. That is sufficient. Yes, he has become the chronic defaulter in payment of rent, and also that the lease period has expired. Hence, I caused a termination of tenancy notice by issuing notice under section 106 of C.P.C, terminating the tenancy, and he is no more be a tenant under me, and his continuance of the scheduled premises is unlawful and illegal. Therefore, he is liable to be evicted, and that he shall be paid damages for using the property illegally and unlawfully. Despite of the notice, he has neither vacated nor paid the damages. Hence, it is a suit for ejectment, possession, and for damages. These are the pleadings, isn't it? In case of a tenant and landlord relationship. ಅದಕ್ಕೆ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅನ್ನು ಒಂದು ಕೇಸ್ಗೂ ಮತ್ತೊಂದು ಕೇಸ್ಗೂ ವ್ಯತ್ಯಾಸ ಇರ್ತದೆ. ನಾವು ಸ್ಪೆಸಿಫಿಕ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅನ್ನ ನಮಗೂ ಅರ್ಥವಾಗಬೇಕು, ಆಪೋಸಿಟ್ ಪಾರ್ಟಿಗೂ ಅರ್ಥವಾಗಬೇಕು, ಕೋರ್ಟ್ಗೆ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಬೇಕು. ಯು ಗಾಟ್ ದಿ ಪಾಯಿಂಟ್, ದಿ ಪರ್ಪಸ್ ಆಫ್ ಪ್ಲೀಡಿಂಗ್ ಫ್ರೆಂಡ್ಸ್? ಕೇಸ್ ನಮಗೆ ಅರ್ಥವಾಗಬೇಕು, ಆಪೋಸಿಟ್ ಪಾರ್ಟಿಗೆ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗ್ಬೇಕು, ಕೋರ್ಟ್ಗೆ ಮನವರಿಕೆ ಆಗ್ಬೇಕು. ಹಾಗಾಗಿ ನಾವು ಕೇಸ್ನಲ್ಲಿ ಸಕ್ಸಸ್ ಆಗ್ಬೇಕು. ಈ ದೃಷ್ಟಿನಲ್ಲಿ ನಾವು ಪ್ಲೈಂಟ್ ಅನ್ನ ಡ್ರಾಫ್ಟ್ ಮಾಡಬೇಕು ಅಲ್ವಾ? ಇದು ಪ್ಲೀಡಿಂಗ್ಸ್ ಪಾರ್ಟ್ ಆಫ್ ಇಟ್. ಇನ್ನು ಪ್ರಮುಖವಾದ ಅಂಶ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಯ್ತು. ದ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್ ಈಸ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್. ಇಟ್ಸ್ ಎ ವೆರಿ ಬಿಗ್ ಓಷನ್. ಇದು ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತಂದ್ರೆ ಅದನ್ನ ಡಿಸ್ಕ್ರೈಬ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ವಿ ಕೆನಾಟ್ ಪುಟ್ ಇಟ್ ಇನ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ಸಾಕೆಟ್, described in a narrow campus or a straight jacket formula. But cause of action arises. Nodi, yen cause of action is a bundle of events. Aste, one word alli helabodu. Bundle of events andre aa bundle alli nimage yavag suit agutto adna tagolli alli plead ಮಾಡಿ ಅಷ್ಟೇನೆ. In case of cause of action for a suit for injunction ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, threat of dispossession. ಹೌದು, ಇಂಥ ದಿವಸ ಬಂದು ಥ್ರೆಟ್ ಮಾಡದ ನಾನು ಹೊರಗಡೆ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿ. ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ದೇರ್ ಆರ್ ಟೂ ಕೈಂಡ್ಸ್ ಆಫ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್. ಒಂದು ಪ್ರೊಸೀಜರಲ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂಡ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್. ಏನ್ ಪ್ರೊಸೀಜರಲ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಏನು? ಇನ್ ಕೇಸ್ ಆಫ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, ರೈಟ್? ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಆನ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ಟೈಮ್ in a particular place, these persons, when I am in physical possession, have disturbed me and threatened to dispossess me, is a cause of action for the suit for injunction. Only two things in a suit for injunction, right? Cause of action, threat. Yes, sir. To maintain the suit for injunction. Whereas in case of a declaration, cause of action ಯಾವುದಾಗುತ್ತೆ? A party must assert his rights and the other party must deny the right of the plaintiff. Assertion and denial leads to the list, which list has to be adjudicated finally, substantially, the rights of the parties after thorough trial. That is the cause of action. that list leading to further proceedings to decide or adjudicate the controversy between the parties in a competent court of law. This has answered section 11, section 10, section 2 subclass 2. Even the concept ideyalla section 2 subclass 2 decree ಅಂದ್ರೆ ಏನು ಅಂತ ಡಿಫೈನ್ ಮಾಡ್ತು ನಾವು ಹೇಳ್ದು ಏನಂತ a court which has got a competent jurisdiction to try between the same parties in respect of the very same lists or the controversy adjudicated finally and substantially is also decree as defined in section 2.2. And if a competent court has finally decided the issue in a former suit, cannot be tried in a subsequent suit. If so, it is res judicata, and the suit has to be dismissed on the ground of res judicata. It attracts Article 20, subclass 2 of the Constitution of India. Article 20, subclass 2 of the Constitution of India. See, no person, double jeopardy. No person shall be vexed twice for the same commitment, for the same offense. See, continuation of a frivolous litigation, false litigation amounts to crime. Alva, you can very well invoke 220 plus 2. Right to life includes the right to lead a decent life, happy life, peaceful life. When his life is at danger or jeopardy or vexed, then it amounts to violation of Article 20 plus 2. Definitely you can plead this whenever necessary. Section 11, why can't you refer this? Always, at the cost of the judicial time, at the cost of the parties concerned, if this suits were to be repeatedly committed, that has to be nip and the bud itself. Yes. So the cause of action is a very, very important area of a pleadings ಅಂತ ಹೇಳೋಣ. ಸೂಟ್ ಅಲ್ಲೋದೇ ಬರ್ತದೆ. ಯಾಕೆಂದ್ರೆ section 6 or 8 rule 6 ಏನಲ್ಲಿ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಅಲ್ಲೂ ಕೂಡ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಬರ್ತದೆ. ಅದಕ್ಕೆ ನಾನು ರೆಫರ್ ಮಾಡ್ತಿದ್ದೇನೆ. Yes, friends. Then yet another important is you have to specify the jurisdiction ಹೇಳ್ಬೇಕಾಗ್ತದೆ. Territorial jurisdiction easy find out ಮಾಡಬಹುದು. You have to specifically value the suit for the purpose of jurisdiction and for the purpose of court fee. Right? So you must specify the value of the property for the purpose of jurisdiction. Monetary jurisdiction ಬಗ್ಗೆ ಹೇಳಬೇಕಾದಾಗ specifically plead that you have to calculate the court fee depends on the nature of the suit. Section injunction suit ಆದರೆ section 23C ನಲ್ಲಿ ಹಾಕ್ತೀರಿ. Insofar the declarations section 24 A, B, C, D. Nature of the declaration. General declaration ಬೇರೆ, specific declaration ಬೇರೆ. Suit for possession ಗೆ 39 ಹಾಕ್ತೀರಿ. ಹೀಗಾಗಿ ಇವೆಲ್ಲ ಎಲ್ಲೋ ಲಾ ಗೊತ್ತಿದ್ರೆ ಮಾತ್ರ ಪ್ರಾಪರ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಹಾಕಕ್ಕಾಗೋದು ಅಂತ ನಾನು ಹೇಳಿಕ್ಕೆ ಇದನ್ನ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ವೇರಿಯಸ್ ರೆಫರೆನ್ಸಸ್ ಆಫ್ ದ ಡಿಫರೆಂಟ್ ಆಕ್ಟ್ಸ್ ಇವೆಲ್ಲವೂ ಗೊತ್ತಿರುತ್ತಾನೆ. ಪ್ಲೇಂಟ್ ಹಾಕಿರೋದು ಕೋರ್ಟ್ ಫೀನ್ ಸೂಟ್ ವ್ಯಾಲ್ಯೂಷನ್ ಗೊತ್ತಿರಬೇಕು, C.P.C ಗೊತ್ತಿರಬೇಕು, ರೈಟ್ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್ ಗೊತ್ತಿರಬೇಕು. ಅಂಡ್ ಸ್ಪೆಸಿಫಿಕ್ ರಿಲೀಫ್ ಆಕ್ಟ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. Section 37 injunction, 38, section 39, right, mandatory injunction, certain 41 court cannot grant reliefs in certain cases. Specific relief act is very, very important to plead a proper plaint and the written statement from substantive law. ಅದು ಬಹಳ ಮುಖ್ಯ ಆಗ್ತದೆ. ಆಯ್ತಾ? ಆಮೇಲೆ the next is prayer part. ಪ್ರಾರ್ಥನೆ. ಅದು ಪ್ರಾರ್ಥನೆನೇ ಆಗಿರ್ಬೇಕು. ಯಾವಾಗ ಸರಿಯಾದ ಪ್ರಾರ್ಥನೆ ಆಗಿರ್ತದೆ ನಿಮ್ದು? when you will pray, ಅದು ಭಕ್ತಿ ಪ್ರಧಾನವಾಗಿದ್ದಾಗ, ಸತ್ಯ ಪ್ರಧಾನವಾಗಿದ್ದಾಗ, ಅಲ್ಲಿ ಮೇಲೆ ಹೇಳ್ಕೊಂಬರತಕ್ಕಂಥ ಎಲ್ಲಾ ಅಂಶಗಳು ಕೂಡ ಸಮರ್ಥವಾಗಿದ್ದಾಗ you can blindly pray for the relief sought because you have pleaded properly, therefore you will get the proper prayer. Prayer ಅಲ್ಲಿ ಎರಡು ಅಂಶ ಇದೆ, ರೈಟ್? ಎರಡು ಅಂಶ ಅಂತ ಹೇಳಿದ್ರೆ ಒಂದು ಮೇನ್ ಪ್ರೇಯರ್ ಅಂಡ್ ಕಾನ್ಸಿಕ್ವೆಂಟ್ ಪ್ರೇಯರ್. ಇವಾಗ mere suit for declaration, pray for declaring that you are the owner of the scheduled property is not sufficient. You must consequently pray for the injunction. ಕೆಲವು ಕೇಸಲ್ಲಿ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ರಿಲೀಫ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಮೇನ್ ರಿಲೀಫ್ ಕೂಡ ಬರಲ್ಲ ಕೋರ್ಟ್ಗೆ. Therefore, you must very carefully pray. The prayer column is very, very important. And ಕೆಲವುದು, when you pleaded, see the illegal construction in the, right? When you have pleaded, demolish the illegal construction and you have pleaded an encroachment by the other party, you must seek the prayer of declaration that you are the owner of the property and for possession of the encroached property. Mere suit for declaration without seeking a consequential relief of the possession of the encroached property is not maintainable. Whereas in case of a specific relief act, since a discretionary power has been granted under section 20+2 of the specific relief act, right? However, the amended act of 2018 has taken away the discretionary power of the court. ಇದು ಒಂದು ಒಳ್ಳೇದೇ ಆಯ್ತು. ಡಿಸ್ಕ್ರಿಷನ್ ಹೇಗೆ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ತಿದ್ರು ಒಂದು ಬೇರೆ ಆಗಿದೆ. ಈಗ ಅವಾಗ ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, ವೇರಿನ್ ದಿ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್, ಇಲ್ಲಿ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ರಿಲೀಫ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಆಲ್ಟರ್ನೇಟಿವ್ ರಿಲೀಫ್. ದಯವಿಟ್ಟು ನೋಡಿ ಫ್ರೆಂಡ್ಸ್, ಇದನ್ನ ಬಹಳ ನೀವು ಗಂಭೀರವಾಗಿ ಯೋಚನೆ ಮಾಡಬೇಕಾಗ್ತದೆ. ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಆಲ್ಟರ್ನೇಟಿವ್ ಪ್ಲೀಡಿಂಗ್ಸ್, ಅಲ್ಲಿ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಆಲ್ಟರ್ನೇಟಿವ್ ರಿಲೀಫ್ ಅಂತ ಕೇಳಕ್ ಬರಲ್ಲ, ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ರಿಲೀಫ್ ಫಾರ್ ಪೊಸೆಷನ್ ಅಂತ ಕೇಳ್ತೀರಿ. Whereas in a suit for specific performance of a contract, consequent alternative relief of refund of amount, advance amount with interest or damages or such other reliefs can be prayed alternatively and not consequentially. Right? That's the difference between consequential. In suit for injunction antandre restraining from perpetually. ಅದಲ್ವಾ? ಇಲ್ಲಿ ಮನಿ ಸೂಟ್ ಅಲ್ಲಿ with interest, right? These are all the relief. And yet another important area in a completed plaint is verification. ಬಹಳ ಮುಖ್ಯ ಅಲ್ವಾ? ನೀವು ವೆರಿಫಿಕೇಶನ್ ಅನ್ನೋದು ಎಂಥ ಪ್ರಮುಖವಾದ ಒಂದು ಪದ ಅಂತ ಹೇಳಿದ್ರೆ, ರೈಟ್? ಇಟ್ ಇಸ್ ಅ ಸಾಂಗ್, ಇಟ್ಸ್ ಅ ಸಾಂಗ್ ಆಫ್ ಲೈಫ್. ಸಾಂಗ್ ಆಫ್ ಲೈಫ್ ಅಂತ ಹೇಳಿದ್ರೆ, ನಾಟ್ ಇನ್ ಓನ್ಲಿ ದಿ ಪ್ಲೈಂಟ್. ವೆರಿಫಿಕೇಶನ್ ಅಂದ್ರೆ ಏನು ಕನ್ನಡದಲ್ಲಿ? ಎಂಥ ಅದ್ಭುತವಾದ ಪದ, ಸತ್ಯಾಪನೆ. ಮೇಲೆ ಹೇಳಿರ್ತಕ್ಕಲ್ಲ ಎಲ್ಲ ಅಂಶಗಳು, ನನ್ನ ನಾಲೆಡ್ಜ್ ಇದ್ದಿದ್ದು ಕೆಲವು, ನಾಲೆಡ್ಜಿಗೆ ಬಂದಿದ್ದು ಕೆಲವು, ಕೆಲವು ಅಂಶಗಳನ್ನ ತಿಳ್ಕೊಂಡಿದ್ದು ಬೇರೆ ಕಡೆಯಿಂದ, ಕೆಲವು ಅಂಶಗಳನ್ನ ನಾನು ಈ ದಾಖಲೆಗಳ ಮುಖಾಂತರ ಕಲಿತಿದ್ದ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನ ಮೇಲೆ ತಿಳಿಸಿದ್ದೇನೆ. ಈ ರೀತಿಯಾಗಿ ಬಂದಂತಹ ದಾವೆಯಲ್ಲಿ ಹೇಳಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಅಂಶಗಳು ಸತ್ಯವಾಗಿದೆ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ನಿವೇದನೆ ಮಾಡ್ತೀನಿ ಅಂತಕ್ಕಂಥದ್ದು ಇದೆಯಲ್ಲ, ಇದು ಸತ್ಯಾಪನೆ. ಬಹು ಮುಖ್ಯವಾದಂತಹ ಕನ್ಸೆಪ್ಟ್ ಇದು ಕಂಪ್ಲೀಷನ್ ಆಫ್ ಎ ಪ್ರಾಪರ್ ಎಫೆಕ್ಟಿವ್ ಅಸರ್ಟಿವ್ plaint, friends. This is in respect of the plaint. Now friends, I will take in ಎರಡು ಸೆಕ್ಷನ್ಸ್ ಅನ್ನ ಹೇಳಿ ನಾನು ವೈಂಡ್ ಅಪ್ ಮಾಡ್ತೀನಿ ಕಾಣ್ತದೆ. ಯಾಕಂದ್ರೆ ಡಿಗ್ರಿ ನನಗೆ ಹೋಗ್ಬೇಕೇ ಆಗಿಲ್ಲ, ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಡಿಗ್ರಿ ಸಿಕ್ಕಿದೆ ನಿಮ್ಗೆ ಬಹುಶಃ. ಇಫ್ ಯು ಕುಡ್ ಅನಲೈಸ್ ಇನ್ ಎ ವೈಡರ್ ಕಾನ್ಸೆಪ್ಟ್ ವಾಟ್ ಈಸ್ ದೇರ್ ಟು ಬಿ ಪ್ರೂವ್ಡ್ ವೆನ್ ಯು ಹ್ಯಾವ್ ಪ್ಲೀಡೆಡ್. ಆಫ್ ಕೋರ್ಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಬೇಕಾಗ್ತದೆ, ಕೊಡ್ತೀರಿ, ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. Within our time limit, we have to effectively understand that. Yes. Now, section order 7 rule 10 ಏನ್ ಹೇಳುತ್ತೆ ಇದು ನೋಡಿ. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹೇಳಿದಾಗಲೇ ಕೂಡ ನಿಮ್ಗೆ ಎಫೆಕ್ಟಿವ್ ಆಗಿ ಹೇಳಿದೆ, ಪ್ಲೇಸ್ ಆಫ್ ಸೂಯಿಂಗ್. If you have not properly selected the place of suing, the plaint will be rejected. Alva, rejection of a plaint order 7 rule 10A. Right? If the plaint is presented in a wrong court, which has no territorial or pecuniary jurisdiction, the court may return the plaint. Alva? So therefore, ಶೀರ್ಷಿಕೆ ಅಂತಕ್ಕಂಥದ್ದು ಕೇವಲ ಫಾರ್ಮ್ಯಾಲಿಟಿ ಅಲ್ಲ ಅಂತ ನಾನು ಯಾಕೆ ಹೇಳಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಈ ಮುಂದಾಲೋಚನೆ ಇಟ್ಕೊಂಡು, if the plaint is not presented before a proper court, then the court may suo motu can reject the plaint. Sorry, return the plaint. Return ಬೇರೆ, reject the plaint ಬೇರೆ. Or upon application filed by the other side can, in a notice ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಸಮನ್ಸ್ ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, court is suo motu take cognizance about the maintainability of the presentation of the, ಇದು maintainability suit ಹೇಳ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ, maintainability of the plaint itself, the court can suo motu order for return of the plaint. While so returning the plaint, the court will make an endorsement saying that please present this plaint, right, in a proper court having proper jurisdiction to try ಅಂತ ಹೇಳಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಮಾಡಿ ಆ ಪ್ಲೈಂಟ್ ಅನ್ನ ರಿಟರ್ನ್ ಮಾಡಬಹುದು ಫಾರ್ ದ ಪ್ಲೈಂಟಿಫ್. ಈ ಒಂದು ಸನ್ನಿವೇಶನವನ್ನ ನಾವು ಯಾತಕ್ಕೆ ತಂದುಕೊಳ್ಬೇಕು? ನಾವು ಪ್ಲೈಂಟ್ ಅನ್ನ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಬೇಕಾದಾಗಲೇ ರೈಟ್ ಟು ಸ್ಯೂ ಎಲ್ಲಿ ಅರೈಸ್ ಆಯ್ತು, ಯಾವ ಕೋರ್ಟ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಇದೆ ಅಂತ ನಾವು ವೆರಿಫೈ ಮಾಡಿ ಹಾಕಿದಿದ್ರೆ, ದಿಸ್ ಸಿಚುವೇಶನ್ ವುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಅರೈಸನ್ ಫಾರ್ ದ ಪಾರ್ಟೀಸ್. ಇಲ್ಲಿ ದ ವಿಸ್ಡಮ್ ಆಫ್ ಎ ಲಾಯರ್, ಕೇರ್ಫುಲ್ನೆಸ್ ಆಫ್ ಲಾಯರ್ ವುಡ್ ಬಿ ಪ್ಲೀಡ್. ರೈಟ್, ಆಯ್ತು. ವಾಟ್ ಈಸ್ ದಿ ಎಫೆಕ್ಟ್ ಆಫ್ ದ ರಿಟರ್ನ್ ಆಫ್ ದ ಪ್ಲೇಂಟ್? ಕೋರ್ಟ್ನವ್ರು ಎಂಡಾರ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದೆ. ಯಾಕೆಂದ್ರೆ ಆನ್ ದಿ ಸೇಮ್ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ದಿ ಪಾರ್ಟಿ ಕೆನಾಟ್ ಪ್ರೆಸೆಂಟ್ ಎ ಫ್ರೆಶ್ ಪ್ಲೇಂಟ್ for want of limitation. Limitation ಪ್ರಶ್ನೆ ಬರ್ಬೋದಲ್ವಾ ಅವಾಗ? ಆದ್ರಿಂದ the court will make an endorsement. From the date of endorsement, the limitation begins to start. If a party wants to file a fresh suit, if he present the very same plaint to the different court on the date of endorsement, no problem. If a party wants to file a fresh suit on the same cause of action, then the endorsement is required. Right. In case if the notice summons is issued and the defendant has filed his objections taking the contention that the suit is not maintainable for want of jurisdiction, then the court may pass an order, right, with an endorsement to present this before a proper court. Then the question would be, when it is presented before a different court, the proceeding shall commence from what date is the question. Whether to that time a few witnesses have been examined, the records have been produced before the court. Whether the de novo proceedings is required or the suit will be continued from the stage where it is stopped. Is a question to be decided by the subsequent court. The Supreme Court has held that in order to avoid the time and other things is only a technical defect committed by a party, why should you call for the witnesses who have also examined earlier and the document will mark, continue from the stage of where it is stopped anta ಒಂದು judgment ಹೇಳುತ್ತೆ. No. fresh cause of action you can go ahead with the de novo proceedings. So again, it is a discretionary power under section 20. Subsidiary powers of the court ಅಂತ ಬರ್ತದೆ section 20 ನಲ್ಲಿ. ಅದನ್ನು invoke ಮಾಡಿ court can either commence de novo proceedings or continue the same case where the proceedings. So therefore, this is the significance of return of the plaint under order 7 rule 10A. Under 7 rule 10A, this is the important significance which we have to note down. Well, friends, now I'll come to section 7 rule 11. 7 rule 11 A, B, C, D. See, when a plaint has to be rejected, this is very, very important, which I have very carefully and in detail has pleaded the ingredients of the plaint while dealing with order 7. Right? Then under what circumstances plaint will be rejected? The first and foremost stage of rejection of plaint is when there is no cause of action. Right? When there is no cause of action pleaded or established, the plaint may be rejected by the court. Then, when the suit is barred by any other law, as you have discussed in section 9 of the C.P.C, impliedly or specifically or expressly barred by law to entertain the suit, the court may reject the plaint. Alva? When there is no cause of action is very important to tell you because of this reason. And the bar of the suit, the second. And thirdly, when the suit is undervalued, the court take notice of the fact of undervaluation of the suit and granted time to the party to make good the stamp or the court fee within a reasonable time. If the party has not complied with the terms of the directions of the court, then also the court can reject the plaint. Insofar as the rejection of the plaint is concerned, one the landmark judgment I will give you. If you read this judgment whenever you are free, you will completely know. You need not go 100 judgments, 100 of judgments idave rejection of the plaint ಬಗ್ಗೆ. ಅದೆಲ್ಲಕ್ಕಿಂತಲೂ ಮೂಲ ಏನಿದೆ, ಇದು the Honorable Justice Krishna here ಬರೆದಿರೋ ಈ ಕೇಸು. ತಾವು ಇದನ್ನು ಓದಿದ್ರೆ ಸಾತ್ explanation ಗಿನ್ನ. Yes, 1977 SC 274 ಅರವಿಂದಾನಂ ಕೇಸ್ ಅಂತ ಲ್ಯಾಂಡ್ಮಾರ್ಕ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅರವಿಂದಾನಂ ಕೇಸ್ ಇದು ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ನಿಂದಲೇ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿದೆ. ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂತಂದ್ರೆ ಏನು ಅಂತ, ಹೌ ದ ಮುನ್ಸಿಫ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಟೇಕನ್ ದಿಸ್ ಇಂಪಾರ್ಟೆನ್ಸ್ ಫ್ಯಾಕ್ಟ್ ನಾಟ್ ಕನ್ಸಿಡರ್ ಅಂತ ಹೇಳಿ ಎಲಾಬರೇಟ್ ಆಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದಿದ್ದಾರೆ. ಅದು ಆರ್ಡರ್ 7 ರೂಲ್ ಈಸ್ ಎ ಲ್ಯಾಂಡ್ ಮಾರ್ಕ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅದು ಗೀತಾ ಅಂತಲೇ ಹೇಳ್ಬೋದು. ಎಸ್, ಭಗವದ್ಗೀತೆ so far as plaint is concerned. You must go through that. Then, friends, what is the effect of the order 7 rule 1? Whether the party can file a fresh suit when the plaint is rejected. Alva? When it is written, the party can file a fresh suit. When the plaint is rejected, it amounts to decree. Please bear in mind. It amounts to decree. No fresh suit is required to be filed, and no fresh suit is maintainable when the plaint is rejected. The decree is amenable to an appeal under section 96 of the Code of Civil Procedure. So now, friends, we have, I think, effectively undergone or discussed or traversed very relevant sections and very relevant orders and rules up to the plain. In ಮುಂದೆ ಇರತಕ್ಕಂಥದ್ದು plaint ಆದ್ಮೇಲೆ written statement is alike that of the plaint in its procedure and in so far as pleading is concerned. And if the pleadings are completed, issues will be framed under section 14. And issues may be varied and to be modified on the application. Then the matter will be posted for trial, for adjudication of the controversy between issues. Evidence will be let in, the procedure will be complied, and finally the matter will be heard and the decree will be passed. Now we are at the point of decree, and the decree is amenable to an appeal under section 96 of the code. So what is important here? The preliminary issue. If we succeed in preliminary issue, we'll also get succeeded in decree. Yes. What is an appeal? In two sections. Section 96, appeal from the original decree. Depends on the jurisdiction again, is which is an appellate court to which decree. Again, it is depends on the nature of a pecuniary jurisdiction. Suppose if the value of the properties exceeds 15 lakhs, senior civil judge will be the jurisdiction in the trial courts, and then high court exceed 15 lakhs adre high court to single judge bartade up to 15 lakhs, exceed 15 lakhs division bench bartade RFA anta bartade, regular first appeal, right? Section 96. You know the powers of the 96 adu bekagilla nim purpose ke. See, for the purposes of the civil judge examination, appeal is a different area. Again discuss madiddu adu baala mukkavaagtade. To conclude in a proper way, I will say appellate court has power or jurisdiction of the pada sukta agtade, has power to confirm the decree and dismiss the appeal, or power to re-examine, reappreciate the contents of the decree, and if it found that the decree is erroneous in fact and law, then it can set aside the decree. Or if the appellate court found that the decree requires to be reconsidered by the trial court itself, it would remand. By setting aside the decree, it can remand the matter to the trial court for reappreciation and re-adjudication. This is the first appeal, the powers of the first appeal. That is section 96. Insofar as the second appeal under section 100 is concerned, the second appeal, the high courts have will not interfere normally the concurrent findings of the trial courts. If at all, if the high court satisfies that there is a substantive question of law to be decided at a later stage, then only the court will entertain the second appeals before the high court under 100 C.P.C. So, well, friends, so from order, from the date of place of initiation for proceedings to the second appeal in a given time, I have selected few relevant sections and orders and have presented my own way. If the presentation is communicated to you, I'll be so happy, by which I learned a lot. I would not have made my preparation without an opportunity being given to you. I am one among you in the place of learning, and thank you for your patience hearing. Thank you.
Yes, thank you very much, sir. Thank you very much. It was an elaborate and detailed discussion. ಅದು ಈಗ ನಾವು 3 hour ಪಾಠ ಕೇಳಿದ್ಕೆ ಈಗ CPC ಇಟ್ ಇಸ್ ವಾಸ್ಟ್ ಲೈಕ್ ಓಷನ್. ಸೊ ಅಂತದ್ದು ಈಗ ಇಷ್ಟು ನೀವು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಆಗಿ ಕಂಪ್ಲೀಟ್ ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಬಿಟ್ರಿ. ಕಂಪ್ಲೀಟ್ ಯು ಹ್ಯಾವ್ ಕಂಪೈಲ್ಡ್ ದ ಹೋಲ್ CPC ಫ್ರಮ್ ಡಿಕ್ರಿ ಟು ದ ಎಂಡ್ ದ ಟ್ರಯಲ್. So you have completed each and every part in a detailed way. So ನಮ್ಗೆ 100 points ಗೊತ್ತಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ 10 ಪಾಯಿಂಟ್ ಬರೀಬಹುದು. ಸೊ ಆ ರೀತಿಯಾದಂತ ಒಂದು 100 ಪಾಯಿಂಟ್ಸ್ ನ ಒಂದೊಂದು ವಿಷಯದಲ್ಲಿ ತಾವು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ನಾನು ಭಾವಿಸ್ತೀನಿ. ಸೊ ಬಹಳ ಅದ್ಭುತವಾಗಿ ತಮ್ಮ ಲೆಕ್ಚರ್ ಕ್ಲಾಸ್ ಅನ್ನ ನಾವು ವಿ ಹ್ಯಾವ್ ಅಬ್ಸಾರ್ಬ್ಡ್ ಅಂಡ್ ಅಸಿಮಿಲೇಟೆಡ್ ಇನ್ ಅವರ್ ಮೈಂಡ್. ಸೊ ಆ ನಿಟ್ಟಲ್ಲಿ ಸೊ ಬಹಳ ಅದ್ಭುತವಾಗಿ ಒಂದು ಈ ಸೆಷನ್ ನ ನಡೆಸ್ಕೊಟ್ಟಿದ್ದೀರಿ. ನನಗೆ ಒಂದು ನೆನಪು ಬರ್ತಾ ಇದೆ ಏನು ಅಂತಂದ್ರೆ, ದೋಸ್ ಹೂ ಲಿವ್ ಫಾರ್ ಅದರ್ಸ್ ವಿಲ್ ಲಿವ್ ಫಾರ್ ಎವರ್ ಅಂತ. ಐ ವಿಲ್ ರಿಪೀಟ್, ದೋಸ್ ಹೂ ಲಿವ್ ಫಾರ್ ಅದರ್ಸ್ ಹೂ ಲಿವ್ ಫಾರ್ ಎವರ್ ಅಂತ ಹೇಳಿ. ಅಂದ್ರೆ ಯಾರು ಇನ್ನೊಬ್ರಿಗೋಸ್ಕರ ಬದುಕ್ತಾರೆ ಅವರು ಶಾಶ್ವತವಾಗಿ ಉಳಿತಾರೆ ಅಂತ ಹೇಳಿ. ತಾವು ವಕೀಲರು ಒಂದು ವೃಂದಕ್ಕೆ, ವಕೀಲ ಒಂದು ಸಮುದಾಯಕ್ಕೆ, ಅವರ ಒಂದು ಜ್ಞಾನಾರ್ಜನೆಗೆ ತಾವು ಬದುಕ್ತಾ ಇದ್ದೀರಾ ಅಂತ ನನಗೆ ಭಾವಿಸ್ತದೆ. ನೀವು ಯಾವಾಗ್ಲೂ ಶಾಶ್ವತವಾಗಿ ತಮ್ಮ ಹೆಸರು, ತಮ್ಮ ಕೀರ್ತಿ ಉಳಿತದೆ ಅಂತ ನಾನು ಭಾವಿಸ್ತೀನಿ. ಹೀಗೆ ತಮ್ಮ ಸೇವೆ ಮುಂದುವರಿಲಿ ಅಂತ ನಾನು ಭಾವಿಸ್ತಾ ತಮ್ಗೆ ಅತ್ಯಂತ ಒಂದು ಕೃತಜ್ಞತೆಗಳನ್ನ ಸಲ್ಲಿಸ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಪುರುಷೋತ್ತಮ್ ಸರ್, ನಾನು CPC ಇವತ್ತೇ ಫಸ್ಟ್ ಪಾಠ ಮಾಡಿದ್ದು ಫಾರ್ ಇನ್ಫಾರ್ಮೇಶನ್.
ಹೌದಾ? ಇಲ್ಲ, ಚೆನ್ನಾಗ್ ಬಂತು.
ಇಲ್ಲ, ನಾನು ಪ್ರಿಪೇರ್ ಆಗಿದ್ದೆ. ಬಿಕಾಸ್ ಬಹಳ ಮುಖ್ಯವಾಗಿ ಯಾಕೆ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ, ಮೇಷ್ಟ್ರು ಕೆಲಸ ಬಹಳ ಜವಾಬ್ದಾರಿಯುತವಾದ ಕೆಲಸ. ನಾವು ಮಾದರಿಯಾಗಿರ್ಬೇಕು ತಾನೆ. ಆಮೇಲೆ ಸಿವಿಲ್ ಜಡ್ಜಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಎಲ್ರೂ ಬುದ್ಧಿವಂತರೆ. ಫಸ್ಟ್ ನಮ್ಮ ಮುಂದೆ ಬುದ್ಧಿವಂತರಿದ್ದಾರೆ, ಅವರೊಡನೆ ನಾವು ಸಂವಾದ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಒಂದು ಈ ಧನ್ಯತಾ ಭಾವ ಇದೆಯಲ್ಲ, ಅದನ್ನ ಇಟ್ಕೊಂಡು ನಾವೇನೇ ಕೆಲಸ ಮಾಡಿದ್ರು ಕೂಡ ನಮಗೆ ತೃಪ್ತಿ ಸಿಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಸರ್. ನೀವು ನೋಡಿ, CPC ಅವತ್ತು ಹೇಳಿದ್ರಿ CPC ಹೊಸ ಸಬ್ಜೆಕ್ಟ್ ಸರ್. ಇಲ್ಲ, ನೀವು ನಾನು ಮಾಡ್ತೀನಿ ಅಂತ ಇಮಿಡಿಯೇಟ್ ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟೆ. ಐ ಆಮ್ ವೆರಿ ಗ್ರೇಟ್ಫುಲ್ ಟು ಯು ಬಿಕಾಸ್ ಯು ಟ್ರಸ್ಟೆಡ್ ಇನ್ ಮೀ, ಬಿಕಾಸ್ ಯು ಹ್ಯಾವ್ ಸೀನ್ ಎಂತೆಂತ ಮೇಧಾವಿಗಳಿದ್ದಾರೆ ನಮ್ಮ ಪ್ರೊಫೆಷನ್ ಅಲ್ಲಿ ಅಲ್ವಾ. ಅವ್ರಿಗೆಲ್ಲ ಗೌರವ ಕೊಡೋಣ ಫಸ್ಟ್. ನಮ್ ಕೆಲಸ ಕಲಿಯೋಣ, ಗೌರವ ಕೊಟ್ಟು ಕಲಿಯೋಣ. ಆ ಮಧ್ಯದಲ್ಲಿ ನನ್ನ ಒಬ್ಬ ವೆರಿ ಸ್ಮಾಲ್ ಪರ್ಸನ್ಸ್ ನೀವು ಗುರುತಿಸಿ ನನಗೊಂದು ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಐ ಆಮ್ ವೆರಿ ಗ್ರೇಟ್.
ಇಲ್ಲ, ದ ಥಿಂಗ್ ದಟ್ ಐ ಸಿ ಡೆಡಿಕೇಶನ್ ಇನ್ ಯುವರ್ ಲೈಫ್ ಅಂಡ್ ಯುವರ್ ಕೆರಿಯರ್. ಡೆಡಿಕೇಶನ್ ಅನ್ನ ಐ ಹ್ಯಾವ್ ಅಬ್ಸರ್ವ್ಡ್. ತಾವು ಎಷ್ಟು ಗಂಟೆಗೆ ಹೇಳಿರ್ತೀರಿ ಅಷ್ಟು ಗಂಟೆಗೆ ರೆಡಿ ಆಗಿರ್ತೀರಿ. ಪಂಕ್ಚುಯಾಲಿಟಿ, ಡಿಸಿಪ್ಲಿನ್, ಡಿವೋಷನ್, ಡೆಡಿಕೇಶನ್, ಡಿಟರ್ಮಿನೇಷನ್, ಡಿಸಿಪ್ಲಿನ್, ಎವ್ರಿಥಿಂಗ್ ದಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಲರ್ನ್ ಫ್ರಮ್ ಯು. ನಾವು ಕಲಿಯೋದು ನಿಮ್ಮ ಹತ್ರ ಬಹಳಷ್ಟು ಇದೆ. ನೀವು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ನ ಮಾಡ್ತಾ ಹೋಗ್ತೀರಿ. ನೀವು ನಿಮ್ಮದೇ ಆದಂತ ಒಂದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಅಲ್ಲಿ ಅದು ಅರ್ಥೈಸ್ಕೊಂಡು ಹೇಳೋಂಥದ್ದು ಅಷ್ಟು ಸುಲಭದ ಮಾತಲ್ಲ. ಯಾರಿಗೆ ಹೆಚ್ಚು ಎಕ್ಸಾಂಪಲ್ ನ ಕೊಡಕ್ ಬರ್ತದೆ ಅವನ್ಗೆ ಆ ಸಬ್ಜೆಕ್ಟ್ ಗೊತ್ತಿದೆ ಅಂತ ಅರ್ಥ. ಅಂತದ್ರಲ್ಲಿ ಆ ಸಬ್ಜೆಕ್ಟ್ ನ ನಿಮ್ದೇ ಒಂದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ತೀರಲ್ಲ, ಸೊ ದಟ್ ಶೋಸ್ ಯುವರ್ ಎಲೋಕ್ವೆಂಟ್ ಸ್ಪೀಕರ್ ತಾವು. ಅದು ನಿಮ್ಮ ಒಂದು ಅಟ್ರಿಬ್ಯೂಟ್ ನ ತೋರಿಸ್ತದೆ, ನಿಮ್ಮ ಒಂದು ಕೆಪಾಸಿಟಿ, ಮಾಸ್ಟರಿ ಓವರ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ that it shows, and your service is needed for further future younger advocates like us, sir. Thank you very much. Thank you so much for coming over here and for deliberate this session, sir.
Thank you very much.
Thank you. Any questions to be asked to the speaker? ಏನಾದ್ರೂ ಕ್ವಶನ್ಸ್ ಇದೆಯಾ? ಯಾವ್ದಾದ್ರು ಸರ್ ಬಿಟ್ಟಿದ್ರೆ ಅದ್ರ ಬಗ್ಗೆ ಪ್ರಶ್ನೆಯನ್ನ ಕೇಳಬಹುದು. ಒಂದು ಫೀಡ್ಬ್ಯಾಕ್ ಕೊಡಿ, ಯಾರಾದ್ರೂ ಒಂದು ಫೀಡ್ಬ್ಯಾಕ್ ಕೊಡಿ. ಐ ವಿಲ್ ಕ್ಲೋಸ್ ದ ಸೆಷನ್. ಕಾವ್ಯಶ್ರೀ?
Yes, sir.
Kaveshri madam, can you give the feedback?
Sir, really wonderful session, sir.
Okay. Any apart from wonderful session, you want to speak on the deliberation? ಯಾವ
Sir.
ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ನಿಮ್ಗೆ ಬಹಳ ಖುಷಿ ಕೊಡ್ತು, ಬಹಳ ಒಂದು ಸಂತಸ ಕೊಡ್ತು ಅಂತ?
ಸರ್, ಎಲ್ಲಾ ಕಾನ್ಸೆಪ್ಟ್ ತುಂಬಾನೇ ಚೆನ್ನಾಗಿ ಅನ್ಸ್ತಿದೆ ಸರ್. ಅರ್ಥನೂ ಬೇಗ ಇದಾಗಿದೆ ಸರ್ ನಮ್ಗೆ.
ಸಿಂಪಲ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಡ್ತಾರೆ, ಸಿಂಪಲ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡುವಂತ ರೀತಿ, ಮತ್ತೆ ಅದನ್ನ ಎಂಜಾಯ್ ಮಾಡ್ಕೊಂಡು ಹೇಳೋಂಥದ್ದು ಇದೆಯಲ್ಲ, ಅದು ಬಹಳ ಅದು ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡೋಂಥದ್ದು. ಎಂಜಾಯ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ತಾರ, ಅದನ್ನ ಬಹಳ ಖುಷಿಯಿಂದ ಹೇಳ್ತಾರಲ್ಲ, ಅದು ನಾವ್ ಯಾವಾಗ್ಲೂ ಅದನ್ನ ನೆನಪಿಸ್ಕೋಬೇಕು ಅಂತ ನಾನು ಭಾವಿಸ್ತೀನಿ ಸರ್. ಬಹಳ ಅದ್ಭುತವಾಗಿತ್ತು ಸರ್. ನಮ್ಗೆ ಹೆಚ್ಚಿನ ಒಂದು ಮಾಹಿತಿಗಳನ್ನ ಮತ್ತೆ ತಾವ್ ಯಾವ ಬಿಡುವಾಗಿರ್ತೀರೋ ಅವಾಗ ನಾನು ಫೋನ್ ಮಾಡ್ತೀನಿ. ತಾವು ನಮ್ಗೆ ಈ ಕ್ಲಾಸ್ ಗಳನ್ನ ಇಲ್ಲ ಈಗ ಯಾರು ಸೀನಿಯರ್ಸ್ ಗಳು ಎಲ್ಲಿ ಹೇಳ್ಕೊಡ್ತಾರೆ ಅಂತಾರೆ, ಸೀನಿಯರ್ಸ್ ಗಳು ಹೇಳ್ಕೊಡಲ್ಲ. ದೇ ಡೋಂಟ್ ಹ್ಯಾವ್ ಟೈಮ್, ದೇ ಆರ್ ಹ್ಯಾವಿಂಗ್ ಅ ಟೈಮ್ ಟು ಅರ್ನ್ ಮನಿ. So ಅಲ್ಲ, we should not condemn all the seniors, but there are some exceptions are there, but we will get very less opportunity to learn from the seniors.
Yes, sir.
So here in this juncture, I would like to bring you for more sessions. ನಿಮ್ಗೆ ಮೋರ್ ಸೆಷನ್ಸ್ ಗಳನ್ನ ತಗೊಂಬರೋದು, ಮತ್ತೆ ಕೆಲವ್ರಿಗೆ ಈ ಕೋರ್ಟ್ ಫೀಸ್ ಅನ್ನು ಹೆಂಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡೋದೇ ಗೊತ್ತಿರಲ್ಲ, ಅದನ್ನೆಲ್ಲ ತಾವು ಹೇಳ್ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಒಂದು ಕೆಪಾಸಿಟಿ ಬಿಲ್ಡಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಅಲ್ಲಿ ಅಂತ ಮಾಡಿ ಆ ಪ್ರೋಗ್ರಾಮ್ ಅಲ್ಲಿ ತಮ್ಮನ್ನು ಇನ್ವೈಟ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಸೈಟೇಷನ್ ಹೇಳಿದ್ರೆ ಅದೊಂದ್ ಸ್ವಲ್ಪ ರಿಪೀಟ್ ಮಾಡೋದು.
ಯಾವ್ದು ಮೇಡಮ್?
ಆನಂದದ
ಆರ್ಡರ್ 7 ರೂಲ್ 11 ಏನಮ್ಮ
ಸರ್? ಸೆಕ್ಷನ್ 9 ಸರ್, ಕೋರ್ಟ್ ಟು ಟ್ರೈ ಆಲ್ ದ ಸಿವಿಲ್ ಸೂಟ್ಸ್ ಅಲ್ಲಿ. ರುದ್ರಪ್ಪ ವರ್ಸಸ್.
ಹೌದೌದು, ಹೇಳ್ತೀನಮ್ಮ. ಸೆಕ್ಷನ್ 9 ಇಸ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. 2007(4) KCCR ರುದ್ರಪ್ಪ ವರ್ಸಸ್ ರಾಜೇಶ್ವರಿ. ಬರ್ಕೊಂಡ್ರಮ್ಮ?
ಹಾ ಸರ್, ಬರ್ಕೊಂಡು.
2007(4) KCCR 2756.
Thank you.
Thank you. Thank you, sir.